typing it in.
Thank God it wasn't like a Sunday, right?
It's like KWGR, or like Keller
No, it should be at
Williams
the top.
GR.
Up higher.
But
They changed it because of ease.
And sales meeting, you know, have.
yeah, we're gonna bring that up. Thanks, Adam.
Kindell,
Okay,
you're
so I'll
good.
have you do this too.
Well, if the charger's
If you
different,
don't
it's
have your
all
number,
apart.
that's okay. We can
Sure
find
isn't.
it.
Yeah.
I mean, I can
Alright.
look through my emails and stuff.
Susan, I'm gonna
Yes.
have everybody do a name tag today. We got some new faces in the room today.
You're good.
Thank you, Elijah.
You're texting me. I'm gonna check it, make sure it's good. But
Don't leave me hanging. Come on, you're walking out, leaving me hanging. Thanks, Elijah. All right, and I'm gonna check with Tammy. Morning, Katie, because we still have a couple people, I think, that were in orientation. That's fine.
I
don't think so. I don't think so because.
Good morning. All right, I know Russell was coming too, but he may be running a few minutes behind. Thank you, Dusty. Okay, there's name tags making their way around the room. And then there's also, Aubrey just brought her a little card from orientation. We also have the sign-up sheet so that you get your Con Ed credit today. Hey, Russell.
what's up?
I have to go print some more copies. Where are you at? Over here, bud? There we go. You're welcome. Yes. And a couple more copies. All right, be right back.
It would be down right there in the little back. I think it's not, so give me your name report.
We just have to separate it.
So just pull them apart. Pull mine apart. Oh, yours is like a weird, like, oh, wow. That is crazy.
This is way different than hers.
Just don't let me forget it.
Oh, no.
We're all cousins because we don't know where any of the other two chargers are. I'm sure you can find one somewhere in the house, but.
Really, really safety. No, it's not even the same.
Oh, for real? I guess you're right.
This is turning out very good, John.
I have an adult, but, oh, yeah, it's a 2-week, yeah. Nice. Trying a different lines. Good, how are you?
If you don't have it, bet you can find it.
Yeah.
Josh, did I give you, you got a packet?
Yeah, you got a packet.
Okay. Peyton's gonna need a packet. There
It
we
doesn't go
go.
all the way.
Extra pens.
I think we had it. That was those things so far, so that's it.
You're welcome. Okay. First question then, does everybody have a pen?
Yes.
Okay, so everybody has something to write with. Great. Okay.
You just don't have one, you might want.
And we have several folks that are newer in here today, so yes,
You don't
ma'am.
have an extra computer mouse, do you?
No, not with me, I do at home, so.
Me.
I know Carla said they have one. Check with Carla. Oh, good morning. I said, I know we have a few new faces in here that everybody might not know today. So why don't we just take a second and say your name and like maybe one thing about you and your real estate journey. Joe, you wanna start?
Sure. Joe Taken, my wife works here. I've had my license for like 45 years, since the 70s. I've sold like 2 houses. I was in some of the other stuff with my dad when he was developing properties and all that stuff, but thinking about joining Keller Williams full time.
Okay,
cause I'm retired from stuff and now I gotta do something, and my wife's the go-getter. If anybody knows Luann, she gets it done,
She does.
so that's me.
Okay.
I'm Carrie Harrison, new to real estate. I'm just finishing up one career and starting a new one, so I'm new. That's it, yeah.
Okay.
Yeah.
I'm Susan McDonald. I joined in July, but it has taken me a little while. I was preoccupied with other things, so I'm really getting into it right now. Yes.
My name's Russell Huber. I don't have a name tag.
Katie's gonna get him passed
Oh,
along.
cool.
Yes, I am, I'm doing that right now.
Just everybody knows who you are, Russell.
I guess so. And yeah, I've been doing real estate for like a year and a half or so, and if you guys wanna know what not to do, I can tell you.
Kinda do.
I'm Dusty Lang. I've been doing it, I got my license in August, but then ended my career in November, so now I'm starting this since November, so, yeah, it's been a odd path, but here we are.
Okay. Aubrey?
Aubrey Benting, new to real estate, mom for many years, and then have been doing different things. Group fitness is what I'm coming from currently, but I'm very excited to start real estate.
Fabulous.
Katie Kidder. Let's see, when we lived in Ohio, I got licensed down there. We moved back to Michigan in 2020. Had my license since then. I was with a different brokerage for Clears, and then I came here in September after I stalked Ginger Baxter, and she said yes, I could join. You can continue. Oh. So now I'm here, and I'm making something of myself. So yeah.
One second. Peyton, you're not staying for lunch and after,
No.
right?
No.
Don't put Peyton in
Neither
now.
am
Okay, got it.
Me either.
Your name's.
What?
Your name is.
We missed you, Peyton.
Oh, I'm Peyton. Something about me?
Yep.
I have a cat named Wednesday.
Oh, that's not the right packet. I'll get you one. It's okay.
That's okay.
Glad to have you here. Go ahead and, everybody's, saying names, and we have name tags somewhere. Okay.
My name is Brandy Thompson, and I just got licensed in October, so I am new as well.
Peyton, would you go grab the stuff I've got off the printer right there for me? Thank you. Okay, down to Josh.
I'm Josh Patako. I quit my carpentering job about 3 months ago and pursued the real estate license, and now I'm a new realtor, so brand new to this as well.
Okay.
I'm Karen DeCharnette, and I'm new to this area. We just moved from Oklahoma, so we have a real estate business in Keller Williams in Oklahoma, and so just moved here to be closer to family. And we're in Fairhaven.
Yes, and Kara, you are mainly focusing on the lake shore, right?
Yes,
correct,
I mean,
or-
I don't think you can just focus on one thing.
You
so.
can, but you're over there.
Yeah, cause that's where we live, so.
Okay.
But,
Okay, do you have a pen?
yes, I do.
Okay.
Thank you.
I am Coach Kindell here at North. I have been licensed in Michigan for 12 years. I've been both a solo agent and a team agent. In 2026, I will be closing my 600th transaction, which I'm pretty thrilled and happy. And yeah, we all started somewhere, right? And we have a lot of new people. So remember, there are no stupid questions, and this stuff can get really confusing. And I love, you take that 40-hour class, you get licensed, now you can sell real estate. You know nothing about selling real estate. But it's true, the class does not teach you anything about selling real estate. And this stuff is what you can get sued for or have your career ended over. So I wanna make sure everybody always understands these forms inside and out. So please feel free to ask questions throughout the day. Now it is a lot of material, and there are lots of great topics that come up during these conversations. If it's not directly related to the forms, We're gonna put it on the board, and we can talk about that another time, but we have to stay on target today to be able to get through all of these, okay?
Yes.
Fabulous. And just fun fact, did you guys know that in order to get your cosmetology license, you have to spend 1,600 hours?
What?
Yes.
I do.
Thank you.
Although
So-
it was $12.50 when I got it, but it's increased since
So
then.
1,600 hours to cut somebody's hair, which grows back, and you only need 40 hours to sell someone's largest asset. Great, huh? Yeah. Okay. Another fun fact too is here in Michigan, how many pages are our disclosures? Seller's disclosures. Two. It used to be 2, now it's 4 because they took them to large print, which we needed forever. And did you know that the state of Texas is 62 pages? Wow. Alaska is the largest in the country, which I believe is 113. Which state did you come from again?
Oklahoma.
Here. How many pages? 4. Okay. So we're pretty loosey-goosey. And that's why we get a lot of issues. Okay. I apologize because your packet is not totally in order, because I had somebody else throw them together. So the first page that we're going to start with today is this disclosure regarding real estate agency relationships. And since some of you are fresh out of class, how much do you remember about agency?
There's different kinds.
There are different kinds. What is the most important thing that you need to remember about agency?
Disclosure? Like if you're dual agency disclosure?
Yeah, disclosure too, but the most important part is every agency locks you in as a fiduciary, right? So a fiduciary means that your responsibility is to that party, and that your responsibility is to put their good above your own. And that is one of the things that gives real estate agents a bad name, because you have greedy agents who are only out for a paycheck and they're not looking out for their client's best interest. It's the same as a relationship with an attorney. You may not disclose information about that party to another party without their permission. Okay? This gets signed on the buyer side and on the seller side. So on the seller side, a seller's agent under a listing agreement with the seller is acting solely on behalf of the seller. Yes? Questions about that? Okay. Buyer agent. Under buyer agency agreement with the buyer, you are acting solely on behalf of the buyer. Okay. Dual agents. So a dual agent is when you have information about both parties, right? So you can be the agent of both the seller and the buyer, but only with the knowledge and informed consent in writing of both the seller and the buyer. In a dual agency situation, the licensee will not be able to disclose all known information to either party. So what I always like to say is when you work as a dual agent, you become Switzerland. So I know you guys weren't at our sales meeting on Tuesday, but our broker Ed was having a great conversation about dual agency, what this means, and how that has to factor in. Because there are some people who believe that if you were working as a dual agent, like you gave up half the commission, right? Or that you can't do it. So this is one that I want us to have a great conversation around about today. There are 2 different scenarios. If you have, hey Jada, if you have a listing on the market and you have a sign in front of the property and somebody calls you and says that they want to go see that house, okay? And you say, great, you know, because I am the best person to represent that property on this transaction. How is that legal to say?
Would you already have dual agency
the dual agency discussion with your seller?
Not yet. Good try. You cannot say something like, I am the best person to represent both of you through this transaction, because you're not representing both of them. You have a signed agreement with the seller, you have a fiduciary to the seller. Okay? So that's one scenario. You are signed with the seller, you haven't met the buyer, you don't have an agreement with the buyer, they called off your sign and they're coming to see this property. In that case, you are not going to have dual agency. You are representing the seller, you have a fiduciary responsibility to the seller. What you're going to do is inform that buyer, right, that you are an agent of the seller, but you can absolutely help facilitate the transaction between both parties. And in that case, when we hear like double dip, that's what that is too, because you brought the buyer, you also have the seller, you're entitled to both sides of the commission. But you are a fiduciary of the seller, which means you cannot disclose any information to help that buyer. You also cannot facilitate the buyer, right? Like you can't advise them on legal topics because you don't represent them, you work for the seller. You're just facilitating the transaction. Okay, before I go into the next step, do we have questions on that? Do you understand it or are you confused?
Yes, I understand it.
Okay.
In almost 600 transactions, have you had that scenario?
Yes.
Would you have them, would you fill out a form for this, for that client as well?
Yes.
So you would do that in Oklahoma? So
Yes.
as long as you say, you can hire
So-
me as your agent.
They're not hiring you as their agent. They're hiring you to facilitate the transaction. You have to make that very clear. You do not represent them. You represent the seller. And you are always working for your seller's best interest. So whether they know it or not, if the buyer lets something slip while you're talking to them, you can use that to the benefit of the seller.
Why does it say the licensee will not be able to disclose all known information to either the seller or the buyer?
Because that's a dual agent, which we're gonna talk about in a minute. At this
I
point,
thought
you're
that's what
not
we
a
were-
dual,
oh.
right now, you're not a dual agent. Okay, sorry.
That's where I thought.
I thought we were too.
My apologies.
Those are
Okay,
good.
so there are two different scenarios, but in the scenario that we're talking about right now, you are not a dual agent. And this is why people get very confused with it. Dual agency is a different concept.
But wouldn't you turn that into
So-
being a dual agent then?
No, because you did not have a signed agreement with that buyer prior to your agreement with the seller.
So do you not have to have the agreement before you even show the house? You have to have an agreement signed?
You do, but you don't have to have a buyer agency signed. And if it's your listing, you are not required to have a buyer agency signed for them to come see your property. If you are showing it as the listing agent, and it's your listed property, you don't have to have one. If you're meeting them to go see a listing that somebody else has, you have to have one.
So how did you
Okay.
frame that again? I can best represent this home.
This house, this transaction, this deal. You cannot say I can best represent you. And there are people out there that are very stubborn in their head and do not understand, right, about agency, about representing the seller, and they are convinced that they are going to get the best deal by going to the listing agent. And they are convinced that they're gonna save money by going to the listing agent. They're really screwing themselves over by coming to you as the listing agent. But, I mean, you will have people out there who will not go get another agent. And your responsibility is to the seller. If they wanna buy that house, they're ready, willing, and able, you need to facilitate the sale of the house. Yes, Aubrey?
So when, in this situation, and you're going to represent the seller, but do the transaction for
Mhm.
both, they are not signing a dual agency form or anything?
What they're going to sign is this form, but you are informing those buyers that you are a seller's agent. So my conversation with that person who called me on my listing, I met them there. They're going to buy this house. They want me to do it they don't wanna have their own buyer's agent. And I say, that's great, of course I can do that, you know, I am the best person to facilitate the sale of this house. I do have to disclose to you that I work on behalf of the seller, right? I am the listing agent, the seller's agent on this house. So, we're going to check mark right here that I am acting as a seller's agent, and then they are going to sign right down there on the bottom as a potential buyer.
Could this turn into a dual agency?
No.
Because the buyer didn't.
And here's why. Yes, so let's go into that scenario. Scenario 2, dual agency. It is December. I have a house that's going on the market next week, right? So I am going to be representing the seller. I have this sheet signed with the seller that says I am representing them as the seller's agent. I was working with Joe and Jane Smith since August. And I also have one of these with them that says I represent them as a buyer's agent. It just so happens the house that I list next week is perfect for Joe and Jane. And Joe and Jane want to buy that house that I just put on the market. That is when I become a dual agent. Does that make sense? Because I had a prior relationship, I had a prior agreement with them as well. So at that point, I have a signed fiduciary with both parties. So then I have to inform both parties, right? I represent them and I represent you, which means that I am now going to become a dual agent for this transaction.
So now you get another form signed by both of them that says dual instead of.
Well, you already have it signed for both, yes, but you can go in and because our listing agreement actually says, like in the possibility of dual agency, it explains in there what's gonna happen. But you basically are telling them, now, you know, I am a dual agent. So I have to have both of your consent, right, in writing and in form that I'm gonna do this. So then that's when we tell them, and you have to cover your butt, you don't legally have to have it, to cover your butt, I would have each one of them sign a second one of these forms that I am now a dual agent. And with that, again, you have to have their consent before you share information. So I'm representing both parties, but Jane and Joe say, well, we want them to take $10,000 less. So that's what we want our offer to be. That's what we want you to negotiate. I can't negotiate. I know both parties' situations, right? So even though I may have already knew that the sellers would take $10,000 less, I can't tell that to Joe and Jane. You basically become Switzerland.
But you can present it, you could write it up.
You can write it up, you
And
can
just say,
present
"I'll
it,
present
yes.
it."
But you basically become Switzerland. You cannot share information that you're gleaning from one party or the other without consent to the other party. Yes, Aubrey?
Okay, that makes a lot of sense.
Okay.
Is there a different term for that first scenario where you are like helping facilitate the transaction? Is there a term for that other than just?
There isn't, because technically you are a seller's agent.
Okay.
That's all you are.
But after you show that property, is your job done then for the first scenario? You show the property,
Mhm.
cause it's your listing.
Mhm.
If they wanna write an offer and they have to do it all on their own. You
No,
actually-
you can help them write the offer, but you can't share, you know, any knowledge that you have about the seller to help them sweeten their offer. You represent the seller. So,
How do you
if
get
the,
paid to do
Yeah.
that then?
I feel like
You can charge them a fee, I'll write the contract for you for.
because your contract is with the seller, right, to sell the home.
Yeah.
And when we do that contract on the listing agreement, you are saying, I'm going to charge, let's say I'm charging 6%. I'm going to charge 6% to sell your home. And I'm going to share 3 of that with a cooperating broker if they bring the buyer. I just brought your buyer. So that I'm entitled to that full 6. So that's how you're getting paid. Because your agreement is with the seller. And that's where we get a lot of confusion with buyers who don't wanna get buyer agents, because they think that's gonna save the seller money, and they're gonna be more willing to take their offer because they're not paying 3% out to a buyer's agent. They don't understand that that amount is already negotiated between you and the seller and has nothing to do with them, and you get paid regardless. Right? So, whenever I have those scenarios, and they're basically telling me, yeah, but then, you know, they're gonna take less money because they don't have to pay a buyer's agent, I'm going, I'm sorry, that's not how it works. You know, my commission is negotiated with the seller, and if there is no buyer's agent, I just don't have to share the commission. I get the full percentage. So it's not going to save you any money
But of course,
by
you don't
using
tell
me.
them, you just.
I
say,
will.
"Let's-"
I will tell them.
Oh.
And it really depends on the scenario, and as far as what they're going to choose to do. Some people, right, are just ridiculous they think they know it all, and they're not gonna get an agent no matter what. Fine, I'm gonna do the deal, do the transaction, let's get it done. If I get, you know, some little young couple who really knows nothing about real estate, and somebody told them they're gonna save money by going to me, but you can tell they need help, right? They don't have a clue. I legitimately want what's best for both parties. And usually in those circumstances, I will explain, look, I represent the seller, right? I have to look out for their best interest, not yours. And it's not going to get you any discount. It's not gonna get you any more money off the price. You need to have representation. So I would suggest that we have you work with a buyer's agent so that they can look out for you and your interest throughout this scenario. Okay, so am I giving up part of my commission by doing that? I sure am. Do I sleep better at night because of that? I sure do. And here's the thing. Let's say I'm talking to them and I said, I work with a lot of great agents, and I have one that I know that is phenomenal with buyers. How about I connect you two? Have a conversation. If you feel comfortable and you like her, then use her on your side of the transaction, because I want to make sure that you're covered and protected too. And then I can send that client to Baton and ask her for a referral as well. For facilitating that. Does that make sense?
Yeah.
Okay.
I have a question.
Go ahead, Susan.
Okay, so I've heard recently that if you are a realtor in the state of Michigan and you show a property to someone, you have to either have them sign go and show, or
Yes.
you have to have them sign the buyer agency form.
Yes.
So in this scenario that the person comes to you and you're the listing agent and you're going to show the house to them, wouldn't have you had them sign the buyer agency form?
No. That form is in here, so we're gonna cover that.
Okay.
If it is your property, your listing,
Oh, if it's your
then
listing.
you have permission legally to show it to any interested
Oh.
party, whether they've signed an agreement or not.
Thank you. That was the question.
Yes. So you do not have to have a form for your own property.
So basically, just for that first scenario, you can help the buyer as long as you don't break the fiduciary role with the seller, right? Or obligation to the seller.
Hold on one second.
Uh-huh.
There's my code. Go make me 2 more copies. Okay, ask me again, Josh.
So for that first scenario, just
Yes.
to cover it, it's as long as you don't break your fiduciary obligation to the seller, you can help the buyer in any way.
Yes, you may.
As long as it doesn't break that, right? So that's just the rule for it?
You can. So let's say he's talking about first scenario. We do not have dual agency. We are representing the seller. But the buyer is going to have me facilitate the transaction. The buyer does their inspections, and they find out that the furnace is 22 years old. It's running fine, but it's 22 years old. And that buyer says to me, well, what do you think about this scenario? Do you think I should ask them to replace the furnace? You can't advise them. What you can say is, you can talk to the inspector about it, and you can inform me of what you would like to ask for from the seller. But I cannot advise you on that because I represent the seller. So let's say that right after that, they said to me, well, we're gonna ask them to do it, but it's not gonna be make or break. We just like to see if they fix it for us. Well, I'm now aware of that. So when my seller says, well, should we fix the furnace? I'm gonna go, are you kidding? They're buying the house anyway. We're not gonna fix it.
Right. So that is quite dangerous for them.
It is quite dangerous for them, because you can use any knowledge that you have from what you hear from them for your seller, and that's your job. You're a fiduciary to your seller. Okay, so now do we understand the difference between scenario 1, you represent the seller, or scenario 2, you're now a dual agent?
Yes.
Okay, John just put in one. Oh, okay. Glad you're on there, John. Text me something, or if you have a question today, text me. Okay, so we sign this on both sides of the transaction. So whether you're representing a buyer or you're representing a seller, you must have this agency relationship disclosure filled out. The only difference is it's going to be checkmarked. Are you a seller's agent or are you a buyer's agent? And if you end up representing the seller but have a second person buying it, right, or that's also with you, then I would go back and have them sign another one, both of them recognizing that you are also a dual agent in this transaction. That one's super confusing. Any more questions about this before we move off topic? Go ahead.
I was gonna say, can you repeat the last sentence you just said, that they do
If-
have to check that with.
If you are entering dual agency, so you had an agreement with the buyers months ago and you have your agreement with your sellers,
Oh.
you're going to keep the original form, but you're also going to have them sign a second one that acknowledges that you are now a dual agent. Both parties have to be informed, see, only with the knowledge and informed consent in writing of both the seller and the buyer.
And then with that first scenario, you still just keep the seller's agent, you don't need to do any.
Correct, because you are not an agent for the buyer.
So if you do all this work for this buyer that calls out for the sign
Mm-hmm.
and nothing happens, you just lose that, like, you know what I mean, like, you're not getting the 3%, they didn't buy the house. But you did all their paperwork and made their offers, like, do you charge them anything? No.
No.
Okay. I was just wondering if there was any, like,
There are.
I'll do 1% to do your paperwork or whatever.
Goes to Ashton. No, because you're getting paid by the seller. Remember,
Oh, right,
like if
right,
they're
right.
riding on
Yeah,
your
yeah.
home, but here's the thing, deals fall apart in real estate all the time.
Right, okay,
And that's just par for the course.
yeah.
There are spots on the forms where you can say that you're going to charge them a flat fee to do this.
Oh, okay.
Or XYZ, that's up to you.
Yeah.
I'm gonna say 99% of the agents out there don't.
Right.
It's just not how we do business.
Yeah.
Okay, Susan.
What is the limited service agreement option under both the seller agent and the buyer agent? That's the second box, and then down further, the fourth box.
Where am I going here?
Like right
boxes.
under
The boxes.
When you're checking the boxes, it
Yes.
says seller's agent limited service agreement or buyer's agent limited service agreement.
Okay, so those limited service agreements usually are a flat fee agreement, or those are limited service, like with you've seen these companies, you know, like you go in, you pull the listing up on the MLS, and at the bottom it says, seller will schedule all showings, all offers should be submitted directly to the seller, blah, blah, blah. What they're doing is they're paying like $500 to get it put on the MLS. So in that case, that is a limited service agreement. They're not negotiating, they're not doing anything else on the seller's behalf. They're basically just putting it on the MLS. And that's what that's for. We don't do that here. You have to have permission from me and your broker before you can enter into any of those types of agreements. Okay, other questions on that?
So if you're a seller's agent and you have an open house, and you have different clients that come in without, buyer's agents, can you say, I'll see if I can get them to fix the window for you?
Early morning on
Or can I do this for them, or what can you tell the buyer without being the seller's agent?
Very good question. So as a seller's agent, again, you have to have their permission to share. And that just depends on how you set it up and how you frame it at the very beginning. So when I'm sitting there in my appointment with my sellers and we're going through all their paperwork, because there's a part in the listing agreement too, right, that's gonna ask about that. I say, I am asking you right now to give me permission to share whatever I think is relevant and helpful to get us the highest and best that we can for your home. I've never had anybody say no. And I'm using that, right, at my discretion based on what I think needs to happen. So let's say that when we're touring the home, we know that the window in the living room has a broken pane in it. And the seller has already told me, I'll have that fixed. It's just like 3 weeks out till they can get here. So then I'm doing an open house and somebody goes like, yeah, it's got a broken window. I'm like, no problem. We've already got it scheduled to be fixed. They're just not here yet. Because of course that's something that is a stickler in their mind, right? An obstacle to them buying this home. And my seller has given me permission to share what I feel I need to share to get the home sold.
Just be a little careful then, right? Without volunteering stuff the seller might not wanna fix.
You never volunteer information about anything in the transaction. Again, the number one mistake that real estate agents make is they talk. And what they need to do is keep their mouth shut.
That's why I haven't sold much.
I talk a lot too, but not when you're calling me about one of my homes. And here's the thing again, since a lot of you are new. Kara, I'm gonna pick on you. You are representing the seller, and I have a buyer that's interested in your property, and I ring you up. Ding, 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 ding.
Hello.
Hi, Kara, this is Kindell, Keller Williams. I have an appointment scheduled tomorrow on 123 Main Street.
Yeah, great.
Wonderful. Well, I'm just wondering, it looks like it's been sitting for about 25 days. Can you tell me what's going on with that property?
Well, we've had a bunch of showings and we'd love for you to come check out the property, schedule a showing today.
I ain't giving nothing away. You don't give anything away. And what's happened is you're gonna get an inexperienced agent on the other side of the phone who doesn't know how to keep their mouth shut, and they're gonna go, oh my gosh, I don't know. We've had all kinds of showings, but we're not getting any offers yet, and blah, 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 blah. One person actually made an offer, but then they backed out like 3 days in because I think they got cold feet. And, you know, these sellers, like, they just really want to move. We're going to do a price drop next week of $15,000. Shut your mouth! What did you just tell me? If they're going to do a price drop of 15, I can probably offer them 20 less right now.
Do people actually say that?
They will.
I had
Wow.
someone tell me exactly which price, like they had 3 other offers, they told me all the prices of offers.
Mhm. Well, that's okay.
Oh.
If you have the seller's permission, you can do that. And I will do that too. Like if I'm in a multiple offer scenario, absolutely. I'm gonna play every single one of you off of each other and get as much money as I possibly can for my sellers. But again, it depends on how you present it, right? And how careful you are with who you're telling it to. So, why is your seller moving? It's just time for the next house. None of your business while we're moving. And if I were to say something like, they took a job in Ohio, they know my sellers have to move. Right? They have to sell this house.
Well, I've got an example. I have a listing coming up and I helped him find contractors to give estimates on the wood floors to be redone, but it's an investment property, so he doesn't really want to, and he goes, but I'm willing to pay for the wood floors to be done if it comes up and if it's part of the deal.
Yep.
So I'm not gonna say a word about the wood floors. Unless somebody says, man, these wood floors, then we can talk about it, but otherwise I'm not saying anything.
That's exactly right. So, again, less is more. Okay. We're gonna move on. Because we haven't even gotten to like your actual agreements with anybody yet. But agency is, if you understand agency, and that was your biggest takeaway from today, I have done my job. That's the most important thing that you need to understand. All right, the second page that we're gonna use, this is called the Greater Regional Alliance of Realtors Buyer Showing Agreement. Yes, Katie?
For the agents that are not on teams, who do they go to for questions? Is that you?
That would be me or the broker.
Oh, they're gonna be fine.
Yes. Okay, So this is the buyer showing agreement. This is the one that we're using when you have someone who does not want to sign agency with you yet. Right?
So the go and show?
This is your new go and show. Sure is. Or let's say that, you know, it's not your listing, but somebody called you and they're only interested in this one specific property. Like, I'd move tomorrow, but only if I can buy that house. Then this is the form that you're actually going to use. And this is the form, if you do not have an agency agreement with them, this is the one that you're required by law to have. Does anybody know what the fine is if you get caught showing a home without one of these forms? $5,000. $5,000. And the thing is, right, they will fish to see if they can find people that are doing it. They have testers out there in the world of real estate. And you could have somebody that calls you and says, you know, you popped up in my Facebook feed or whatever, and I want to go see this house, will you show it to me? Now, you can sign it on the hood of the car before they walk through the door. But if you don't have it signed and they're a fish, you will get fined $5,000 and you'll get censured. Sorry. Okay? Very important. So, down here, the top is just all that information. Now, this goes over that compensation of fees. So, there shall be no per showing fee. If the buyer does not enter into an agreement to purchase the property, buyer shall pay a flat fee of blank per showing, payable within so many days after the showing. So, I mean, you can actually charge them a per house fee to open doors, if that's what you want to do. The second part here says, if the buyer enters into an agreement to purchase the property, and the buyer has not signed an exclusive buyer agency agreement with the broker, the buyer shall pay the broker a success fee of blank percent of the purchase price or a flat fee due not later than the closing of the sale of the property. That is the one that most people are going to check mark and fill in. Because basically what you're saying is you're not willing to sign a buyer agency agreement with me today, but they go in, they love the property, they decide they want to make an offer on it, and they're going to have me write it up. Then I'm still entitled to get paid by having number 2 check marked.
So what is your standard, like you would fill in 3% there?
I put in my 3%, the same as I'm going to with my buyer's agent, right?
What would you first present them with the buyer's agent, but just to try to get them to, or not?
It's a yes and no question. So, when you,
Sure.
I would probably try the buyer's agency after we've seen the house, because here's the thing, in this scenario, I'm looking at somebody who probably doesn't know me from Adam.
Right.
They're not going to sign a contract with me to work with them for the next 6 months.
Right.
When they've just met me and had a 10-minute conversation. What I'm going to do is use this as a tool to have great conversations with them while we're going through the house, and then try to have them set up a buyer consultation with me to sign buyer agency and work with me to find their home.
Okay.
They're not gonna sign it right away. Nope.
Unless they know you and they know what.
And in that case, I've already had a buyer consultation, and I already have that stuff signed. This form usually is happening for internet leads, right? Or again, let's say that, you know, Russell has a house that he listed on the market, and maybe that house is already sold, right? Maybe it's already under contract, but they've been seeing his Facebook videos. So they reach out to him and say, I want to see that house. And Russell says, I'm so sorry, you know, like, it's already under contract, but there's another one almost exactly like it right down the road. Would you like to go and see that home with me? And they say yes, right? He's never not met them. First conversation, but he's gonna take them to see that house as his intro way. This is your form that you're using. Jada.
And then, also speaking from personal experience too,
investors are also the same way, like if you're working with an investor, or you have like people that are interested in investing, 9 times out of 10, they don't like signing the buyer agency, they just wanna do the showing. So,
Yeah.
From personal experience too.
Same thing, and Lisa's gonna laugh at me here. I always laugh over this
I
too,
know.
but about twice a year, yes you will, they do these investor seminars, right, that people pay like $800 and they go to this 2-day seminar on how to become an investor and buy real estate. They're scam things. But what they do is they tell everybody, like, you need to go see 5 houses tonight or whatever, and real estate agents' phones will just start blowing up. And so I always warn everybody ahead of time, like, there's an investor conference next week, be prepared. Because that's what they're looking for, and they're just doing what they've been taught in a class. Yep. Okay, questions on that one? Okay, now we're gonna go to the form then, that is actually the form that you use with your buyer consultation. Let me get, usually find that one. And I don't see that we actually have it in the stack here. Oh, it is, sorry. The West Michigan Regional Exclusive Buyer Agency Agreement, designated agency. All right, does everybody have it? Hey, Ashton, when you come back in, will you grab me a Coke out of the door of the fridge?
Yeah.
Thanks.
I'll get her drug, don't worry.
Thanks, Lisa. It is my drug. Okay, now here's the thing. Everybody has a pen. I want everybody filling this out as we go along, okay? This is your example to go back and reference when you have questions on filling this out, okay? Thank you, thank you. And did everybody get the sign-up sheet so you get your Con Ed credit?
Yeah.
No, it didn't hit it on yours.
Susan didn't get it? Okay, let's pass that back up to Susan.
Yeah, I
Oh.
missed you.
Okay,
I
so
don't know if Ashton got
we're
it.
having,
Ashton might need it.
okay, she got it for me. So we're having our, right, our buyer consultation. What other words do we like to use for that?
New buyers meeting.
New buyers meeting, what else do we call it?
Strategy session.
Strategy session, that's my favorite. I don't call it a consultation, I call it a buyer strategy session. Okay, so I want you to write as I go through this, and we're gonna talk through every single piece of it so that you understand it. So this agreement is made between the buyer, so whose name goes there? The buyer. And notice here it says in parentheses, broker. So your agreement there is going to be KW Grand Rapids North. Not your name, the broker name. Line item 1, general description of the property. Buyer wishes to purchase real property, which may include items of personal property, having the following general description and location. Well, we don't know exactly where they're gonna buy yet. They may not even know exactly where they're gonna buy yet. So usually for these, what we do is we put real property in Michigan. And that covers you for anything that you wanna see. Okay, paragraph number 2. This is your designated agency. So this is the paragraph where we're saying the buyer is appointing you to act as their exclusive agent to find the property, to present offers for its purchase, terms, conditions. This is what gives you the ability to act as that designated agent. So it's going to say broker and buyer hereby designate as the designated agent. That is your name. So you are the designated agent. And then broker hereby designates as the supervisory broker. That is Ed Hansen, your broker. Okay, 3. The status shall commence on and shall continue through, so that is your start date and your end date. Right, so your start date would be the day that you're signing all the paperwork. How about your end date?
6 months to a year. Is it for however long you agree to work together?
However long the contract is for. A contract to be valid must have a start date and an end date. That could be 3 months, 6 months, 9 months, a year. But it has to have a start and an end date. Okay, questions on that? All right, now let's get down to your compensation of broker. So this is what's outlining how you're going to get paid. So buyer agrees to pay the broker as follows. Your commission brokerage fee. If the buyer purchases a property or acquires the same by exchange, buyer shall pay broker a brokerage fee of blank % of the sale price or a flat fee of. And again, you cannot fix or set commissions, right? The commission that I'm going to ask for as a buyer's agent is 3%. So that's where I'm going to write in my 3%. Go ahead, Susan.
So in this line, are you also including your, like, if you charge $4.95?
I put that in my other fee.
Yeah, this is where I got hooked up.
Right.
Okay, thank you.
So if you have an administration fee or a transaction fee, that's gonna go in E, the other fee slot.
That's why. Okay, thank you.
Now, some people, again, will just charge a flat fee. When would you charge a flat fee and not a percentage? What? No, you're representing a buyer. Why would I maybe charge a flat fee and not a percentage?
Family. Writing up a deal for a family member.
Family, but really, why would your family members ask you to give up how you make a living?
That's the way they treat me.
Yes. That's why we set them straight. Go ahead, Katie.
When I was in Ohio, there was a couple of vacant land properties that were like $25,000, and because of the lower price, I think my broker charged, I wanna say like $2,000.
She's 100% correct. That is normally for vacant land that are lower price points. Because if I'm helping somebody look at parcels that are $25,000, I'm gonna make $325 off the transaction. And I showed them 10 parcels. Was that worth my $325? No. Okay. But it is either or, not both. Okay? All right. We don't normally do rentals or lease fees, so we're gonna flip through that. Now, this is where part of this lawsuit came into effect, is because when people were having their strategy sessions with their buyers, what they were saying is, well, this is gonna say 3%, but you don't pay that, that's free. You don't pay your buyer's agent, right? The seller's gonna pay my buyer's agent. And that is still the way it works a lot of the time, not always.
No, of course not.
But that's where you're gonna get in trouble. You cannot tell them that your services are free. You cannot guarantee them that your services are going to be paid for by the seller. So when I'm doing that buyer consultation, buyer strategy session, I am setting the stage again of, you know, in real estate, this is how I get compensated, right? So for representing you through the transaction and getting you to the closing table, it will be 3% plus the $4.95 administrative fee. Now, we are going to do everything that we can to ask the seller to pay that 3% compensation. In the case that they are not willing to, then I will disclose that to you and we will factor it into our decision-making process on whether or not you're gonna purchase that house.
Can you repeat that?
Yeah. If they're not willing to, then I will disclose that to you up front, and then we will factor that in and see if you still want to purchase this house. You're not free. You need to make sure they understand how that works. Now, you can also ask your buyer right up front, if a seller is not willing to compensate me that 3%, do you still want to see that property? You can legally do that. You cannot have 5 properties that your seller or your buyer wants to see, and you call every single agent, and one of them tells you they're not offering the 3% to a buyer's agent, so you just tell your buyer that they can't see the property. You cannot do that. But if you ask them up front, do you want to exclude any property that isn't willing to compensate my 3%? And they say yes, then you may absolutely do that. And again, I don't just take it out, but I tell them they're not willing to compensate for the 3% that we're asking. Because some people are so tight on money, they can't do it.
So seller's agent is disclosing this.
So
on
before,
where, what?
they're not disclosing this. Before the
So how are you
lawsuit,
gonna find out?
not without talking to them.
Okay.
Right, before the lawsuit, it was disclosed right there on the MLS,
Like,
what
we
they were
will not
offering.
be paying,
You
buyer's
cannot
fees.
talk about compensation anywhere on the MLS.
So, but
or
I
through
mean like,
Showtime, or
okay,
through-
so they have to tell you verbally.
You have to call them or text
Okay.
them.
Okay.
Yep. To find out.
And how many times, no, never mind.
It's okay, go ahead. There's no bad question.
No, I just, you know, when you're calling, hey, I have a buyer that wants to check this place out, how many times does it happen where they haven't told you, and you get in there and start getting into this, and they say, well.
If you ask the question, they have to tell you up front.
They do, oh yeah,
They do.
okay.
They
Okay.
have to tell you up front.
Okay.
Those listing agents are waiting for people to call them to ask that question.
Yes.
They're waiting for
Yes.
Yeah,
And when
okay.
we get to the other paperwork, in here too, we're gonna talk about that, because there's certain things that you have to submit with the offer to still get paid.
Sure, okay.
But, right, so before the NAR lawsuit, the MLS page used to state at the bottom, like buyer's agent, and it would say 3%. But the lawsuit eliminated that. You cannot mention compensation anywhere in the real estate transaction that is publicly viewed. So you can't put it on the MLS. You can't advertise it on your Facebook post or anywhere else. You cannot communicate it through showing time, because that was the big workaround that everybody was going to use at first, but you can't, because showing time is part of Flex, which is the MLS, right? So it was really interesting when the lawsuit first happened and all this stuff started changing. We had agents who were getting, you know, those little like round paper things that you can put on your house keys.
Yeah.
Like when they do the boxes, right, and they have them all labeled. We had people that were writing like 3% on those and putting them on a key and then putting them in the Sentry box. But then Sentry is also part of the MLS. So then they came back and went, you can't do that. I mean, people were trying to get really creative with how they were doing it. And now it's, why? All you gotta do is text them. I mean, geez, people.
Why did they want to remove all that from the MLS and public stuff? What was the reason?
So when the lawsuit happened against NAR, and basically every real estate agent in the country, right? You have to be a member of NAR because RAR requires it. So what they said is that, number one, agents were telling buyers that their services were free. And they probably were. A lot of agents did that when it wasn't true. The other reason, or the other condition of the lawsuit, is they said that the real estate industry was collaborating to set or fix prices and percentages to list a house and forcing the seller to pay the buyer's agent. We were never forcing them to pay. That's just how it's always worked. And it works that way because frequently the sellers have the equity to pay for that service when the buyers don't. Right? So the seller pays it here, the buyer gets to take that perk. But then again, when that buyer turns around to sell, now they pay it here and the next buyer gets the perk. Right? It does this. But they were saying that it was collusion or colluding, and that we were conspiring to set percentages and fixers and making the sellers pay for it. And to me, I don't understand how they even ruled that way in the lawsuit, because I think it was 6 plaintiffs that had sold their home that created this lawsuit, and they all said that it was disclosed to them right up front that that fee was variable and that they were not legally required to pay a buyer's agent. They chose to do it. The big reason they did that lawsuit in XYZ is because they've all started their own companies now that are trying to compete with Zillow and with other things in the industry. They wanted money. They sensed that they could get money, and that's what they did.
How often do you call another agent and they are not offering compensation?
Occasionally. It does happen occasionally. And then there are some, as we're going to talk about when we get into that portion too, right, that aren't going to offer buyer broker fee. So then you have to have that conversation with your buyer and say they're not going to pay the 3% with mine. So, you know, if you make an offer, remember that's going to fall back on you in your closing cost. Do you still want to go see this house? Okay, so the big thing to remember is you're not free, and it is ultimately the buyer's decision. You can't just exclude properties because they're not offering compensation. Okay, clear? Okay. And that's why it says broker commissions are not set by law and are fully negotiable.
So on the MLS,
yes,
I had heard from somewhere that I could put it into notes to agent.
You may not. You cannot do anything out of the MLS.
No mention.
You're welcome. And that will get you a fine.
Right, right.
We don't want
And a
those.
slap on the wrist from GRAR.
I mean, if you didn't list a percentage and you just said something like.
You can't say anything about it. Not a word. Okay.
Somebody advised me to do that, so I don't know. Okay, thank you.
Don't take advice by anybody but me.
Apparently.
And Ed.
Oh.
Okay. So yes, I did say that. All right.
Yeah.
Now we get down to credit, right? Buyer will receive credit against any compensation due in an amount equal to any commission provided by the seller or seller's broker. And they understand, right, that by you taking that money, that doesn't say that you're an agent of the seller. So it's just explaining, yes, you represent them. Your protection period, broker shall be paid the brokerage fee if the buyer or someone on the buyer's behalf purchases, exchanges for, or signs an option agreement for the purchase of the property within so many months. I see people leave this blank all the time. Don't leave this blank. This is your protection period. I always put a year in here on this one. Here's what happens. So let's talk about the scenario. Russell, you got this buyer. You've been working with him for like 3 months. You've showed him 15 properties. And he's always convinced he's going to get a deal, right? And, you know, maybe you don't really know what you're talking about and whatever. And you go see a house and it's a for sale by owner, right? But you take him. You find it. You take him to see the house. And then, of course, the owner's phone number is right there on the sign. So after you've done that, then he turns around and he calls the for sale by owner and says, well, we're just not going to tell my agent. Let's do this deal together and cut him out of it. And that way you don't have to pay a buyer's agent. We're all going to save money. If you don't have that filled out, you can get away with that. Okay? Or, second scenario, let's say that he takes them to see a house that's listed by another agent. But somehow or another the buyer gets that seller's phone number. And he calls it and he says, well, like, you know, when's your contract going to end? Oh, we expire in 2 weeks. Great. Let it expire and then we'll do the deal together and we'll cut out all those fees and we'll both save some money. If you don't have that signed, you're not protected. If you do have that signed and they try to purchase that property within 12 months, you are still owed your payment because you were the procuring cause of the sale. They can't go behind your back and cut you out. Okay? Don't leave that blank because people do it all the time. So, prior agency, the buyer is acknowledging that whatever confidential information that you have, right, is confidential. And then with other potential buyers, they may make offers on the same or similar property as the one that they're seeing. So we don't have it happen a whole lot right now, but especially back in the height, 4 years ago when we were getting 35 offers on a property, sometimes there was somebody that had 2 or 3 buyers that all wanted to write on the same property. And that became very difficult to do, right? Because you know what 2 of the other offers are. Okay, and I'm assuming everybody understands right here, right? If it says initials, that they have to initial the bottom of every page. Okay, let's go on to page 2. We're not going to explain all this again because we just learned about it. So that is explaining dual agency to that buyer. Scope of representation. The services of the broker under this agreement shall ordinarily be those services customarily provided by real estate professionals, including consultation with respect to the desirability of particular properties, financing, formulating acquisition strategies, negotiating purchase agreements. Right? We're kind of outlining what we do. However, the buyer agrees not to seek or rely upon advice from the broker with respect to legal and/or tax matters, mechanical, structural or architectural matters, environmental matters, title or survey, or any of the other matters relating to the condition of the property. Broker recommends that buyer consult an attorney or other competent professionals with respect to those matters, and buyer hereby releases claim against the broker related to the matters stated in this paragraph. Again, you don't want to get sued. You cannot be touring a home with a buyer and say, well, this foundation looks great. You are not a foundation expert. You are not allowed to say that. If your buyer asks you, do you see a problem with this foundation? Remember, I am not a foundation expert. Based on what I know, I don't see anything right here that is leading me to believe that there are issues. However, I would still recommend that you get an inspection. That is how you do that.
Okay.
Yes.
I don't know if this happens or if it even could, but what if they do take you to court for what you just said there, and they said that they made a decision based on what you said? It's just hearsay, isn't it, at that point?
All of real estate is hearsay when it
Okay.
goes to court.
So
And
how
it
does
just
that-
depends on who's got the bigger preponderance of evidence.
Oh, okay.
But here's the other thing too. Real estate attorneys are very wary of taking on cases, right? There's a lot of stuff that will never see the light of day in court because it's so difficult to prove, and a lot of it is hearsay. But things like misrepresenting commission, things like, misrepresenting agency, that type of thing, you will absolutely get sued and they'll win. In cases where it's hearsay, it's much more difficult. But still, you do not want to be the cause, right, of anything bad that happens anywhere, especially because your reputation is what's going to keep you in business. So, when you've done 600 transactions, you've seen a lot of crap, and you do become more of an expert on certain things, or things that you've encountered or seen before. So again, I feel fine with my buyers going, I have seen this 2 other times, and this was the scenario then. That doesn't mean that that's the scenario that we're in. We should still have it checked and inspected and investigate XYZ. But this is what I think is probably going to happen in this scenario. Right? Okay. Okay. Here's the other thing. If you're having a phone conversation with your client and it's anything that can be considered iffy or circumstantial or weird, go into command, pull their name up, go into the notes section, document the day and the time of the call, and as best as you can recall what your recollection was of the conversation. Somebody attempted to sue me 2.5 years ago. First time ever. And it was really funny because Jason had just said, like, you're the best kid I've got. Like, nobody ever can come back on you for anything. And then 2 days later, I call him up and go, guess what? But I had everything documented. And I had done everything correctly. Even the 2 real estate attorneys went, she did it all right. You have no case. But the printouts were like this thick from all the documentation that I had. And that was what saved my butt, because the other agent was claiming like conversations never happened and XYZ never happened, and I had the records. Okay, can we keep going? All right. Authorization to order services. Okay. If the broker orders any services on their behalf, this basically says they agree to pay for it. I do not order services on behalf of my buyers, and neither should you. Buyer's financial disclosure, this says that they can and that you are privy to whatever financial information you need to know throughout this transaction to make it happen. Like, no, I don't have to see copies of their bank statements, but I have to know that they've got enough money in the bank to cover the closing cost, right? I have to be able to freely speak with the loan officer. Okay. Indemnification, this is the legal proof that says like they're gonna hold harmless and not sue you. Next page, consent to fees. So this basically states if you've explained everything and they understand how you're getting paid. Number 17, that we do not discriminate. 19, that's what allows you to collect electronic information, like e-signatures. 20, governing law, and then 21 basically says if there's anything else that we forgot, it's all covered right here in this agreement. Okay, and then of course you have your buyers are going to sign, right here, and then they're going to check whether they're married or single on here. Why is that important?
Title.
Has nothing to do with title. Why is that important?
If the home is legally owned by two parties.
Nope.
They're bound to this contract now?
Nope.
Rates.
Nope.
Financial,
You should probably just tell us. It's because of ownership laws in the state of Michigan, right? So let's say that both people bought this property together while they're married, but only one of them is on title. Well, it doesn't matter. If they go to get divorced and they bought it during the marriage, it's marital property. That's what this means, and that's what it's there for. So it doesn't reflect anything about who's on title. But here's the other thing. When you're looking for a home, right, and Joe and Jane are gonna buy a property. Jane is the primary breadwinner. Jane is the person who's getting the loan on her own, even though they're married. Jane is the only person that's going to sign all these documents. If Joe wants to be named on the title, then we have a sheet that we fill out later to give the title that adds his name to the title. But the only person who's going to be signing all the documents is the person whose name is on the mortgage. Okay.
What if they check married, but there's still only one person signing it?
If they're married, you have to have both people signing it.
even though they're not buying it together.
They are buying it together, they're married, it's marital property.
But if only the top person, so the person's married, but
Yeah.
Jane is the only one
Getting
on
the
the mortgage.
mortgage.
And she would check married on here, but then would you still put the husband who's not having the mortgage on here also? Or just Jane, even though she's still married?
Just Jane.
Okay. That's
Because again, it's marital property.
Okay.
Even if Jane buys it without Joe's signature, if Jane bought it while they're married, it's marital property.
Okay.
Joe still has a vested interest in it.
Yeah.
But when it comes to legal documents, they want them clean. So only the person who's on the mortgage is going to sign the documents. Okay, good? Susan?
Can you give an example of like an additional condition, number 22?
I've never seen an additional condition on a buyer's thing. We never use that line.
Okay.
I'm sure it's there for legal
I don't know.
purposes.
All right.
Okay. Now, we have hit 11:15. We need to be done with buyers by lunch. Cause the seller is a whole lot more difficult. But what I'm gonna suggest is everybody take 5 minutes. Get up, stretch around, go to the bathroom. Let's be back and ready to go at 11:20. And then we will get into our actual purchase agreement. And you guys are filling stuff out as we're going along, right?
Yep.
Okay.
All set.
Okay, you're good?
That was good stuff.
Thanks, sir. Glad to have you here
Thank
today.
you, I like listening to it, I see it happening. In the other room when I listen to Liz,
It's north of.
she has a team, so she's gotta watch out what the team
Well,
members
yeah.
say.
I know.
might jump on that team, but I gotta watch what I say.
You do. You have to be very careful with what you say. Okay. It is in your doc, Luke.
This is a nice office, my wife likes it down here.
I'm so glad.
Yeah.
Except I rarely get to see her, because I know they're so busy that, yeah.
Busy, she's a go-getter.
Yep. Alright, I am going to go visit the restroom real quick too.
Thank you.
You're welcome.
See you later.
You out the door, Chica?
I think us two are gonna see
So the
Brandy,
baby's
can
got
I ask you one super quick question?
Yes, absolutely.
Do you remember on Tuesday, Ed said that we needed to put the buyer broker compensation reference sheet in a specific spot on the purchase agreement?
It's not on the purchase agreement, it's with the purchase agreement.
Do we have to
So you have a second sheet.
Yes.
Can you do it two ways, if you can write it into the, in that one section on the purchase agreement, and if you can add.
You can, but you shouldn't be.
Are we
And it's not an
mentioning
either or. So,
under other provisions?
no, so if the, here, give me your sheets right here. So if they are offering cooperating compensation.
Oh, yes.
Okay, then there's a sheet in here.
Yes.
That's brokerage fees.
I've got this sheet filled out, but do we have to mention it on the purchase agreement?
So usually what I do then is on that portion, I will put C broker compensation addendum,
Are you putting it under
On-
provisions or seller?
not under seller concessions, it's under other provisions.
I did it right.
Yes, the seller concessions are when you're asking them to give you money. So if that is a buyer broker agreement, if they say, we're not offering a cooperating compensation, or if they say, like, the seller has to decide what they're gonna pay or blah, blah, then that's when they're gonna put it in the line item 27, and you're going to ask seller to contribute 3% towards buyer broker fee. But if they're offering cooperating, you have to submit that the broker to broker compensation.
Yes.
With the purchase agreement, either before or with. If you come back 2 days later and try to submit it, they don't legally have to pay you. Okay.
So just reference everything.
Yep. Got it back.
I like doing it.
What?
Agreement and then referencing it in here. So that it's documented that it was. Thank you so much.
Kinda, are we gonna?
Alright, we're almost ready to roll. Was there an extra?
Here's my third.
Like it's back with these.
Yeah, yours is cuter than mine.
Where'd you get that from?
I got it from the same exact place.
No, I don't think it is.
Leah, here's a copy of all the buyer docs. We're just starting purchase agreement. Okay, yes, thank you. Appreciate that, Becca.
That should be here around like 11:45.
Okay. That sounds great. I'm not really finished with this document by the end, so we're gonna have to speed some stuff up, but we'll get there. Okay. Jada, did you hand these out to everybody else or just have it get passed around? There's your ticket for, attending the class today. All right, let's get started with the purchase agreement. Yay! Woo! This is the great one, right? Because this is how we're gonna get paid. Now, I am going to toggle back and forth here because I'm gonna show you the easiest way to fill these suckers out. Okay, so I'm gonna go and I'm gonna open it. The internet. Alright, and I'm gonna use one that I have under contract right now.
You get two.
Oh, did you get one already? Sorry.
Well, I have two.
Okay.
Oh. She has two out to people.
So, thank you, Jada.
Yeah.
How many of you, please be honest, raise your hand, have not wrote a purchase agreement yet?
Kindell was a different one.
A lot. Okay. I want you to fill this out as we go along. Like exactly like I am, because this is gonna be your reference to go back and look at when it's time to fill out a purchase agreement, alright? When you open something up in Dotloop, it will ask you if you want it to autofill. Tell it no. Because if it autofills, it could write something in a line that you don't want, and it will not let you edit it if it autofills. Okay? Excuse me. So, I have pulled up the West Michigan Regional here in Dotloop. And the first thing it's going to ask us here is the date, right? Okay, so when I click on my little date thingy, it's gonna pull it up and I just click and it adds it in. Alright. We never fill out the time thingies on here. You don't have to have the time thing filled out for a valid contract, and if they sign with Dotloop, it automatically adds a time, right? So never worry about that. So if I am representing the buyer, which office am I on this one? Am I the selling office or the listing office?
Selling.
That's right, I am the selling office. So that's gonna be KW, Grand Rapids North. Alright, and then you're not required to put your broker license number on here. You can, you're not required. Here's my biggest pet peeve in the entire universe. When buyers agents send me an offer and they didn't put their phone number on the contract. Put your phone number on the contract, and it goes right here. Okay, so then the listing office, right, that's going to be the office that has the listing. And the reason I pull it up right here is because I'm just gonna go down. Maybe. And I'm just gonna copy paste it. So this one is Hanson Real Estate Group, so I'm just gonna hit that and I'm gonna copy. And I'm coming right back up here. And I'm gonna paste that in. And then I'm gonna do the same thing with the realtor's phone number. It just will save you a lot of time if you're doing this electronically to copy paste it. Especially because as we get down to this legal description, sometimes the legal descriptions are like this big, and if you write it, it won't fit. But if you copy paste it, a lot of times it will. Okay. Basically, the effective date here is when everybody has signatures on the document. And it says any reference to days in this agreement refers to calendar days, not business days. We work off calendar days. And the first calendar day begins at 12:01 on the day after the effective date. So if we sign everything today, tomorrow is day one. Now, in the top part of the end too, it says effective on the date on which the seller's acceptance of the buyer's offer is delivered to the buyer or the buyer's agent. So this is something else that we've had big conversations about. When you write an offer on a property and you send it over to the agent, and let's say that their sellers accepted it at 9 p.m. that night, but you didn't get notice that they signed it until the following morning, then that now becomes the effective date. It is when your buyer is notified, right? The buyer's acceptance is delivered to the seller or the seller's agent. You'll have a lot of people that don't understand that either. Okay, and when does this become really important? Inspection. Because that's your window of opportunity, right? You have to make sure you understand that. I had an incident, gosh, it's probably been 5 or 6 years ago now. It was a home in Manchester Hills, so it was like 1.3, 1.4 million. And I was actually at family reunion. The buyer's agent had written their contract, they had done their inspections and everything, and he calls me like at lunch that day, and they've got about $30,000 worth of repairs that they wanna have done. And I said, we're not fixing anything, like we don't have to. Well, what do you mean? Well, I'm like, your inspection period ended yesterday. No, it didn't, it ends today. I'm like, nope, it ended yesterday. And they had a $20,000 earnest deposit. So they could still back out, but they're gonna lose $20,000 if they back out, right? And I mean, he is just going on and on to me, and I said, look, I'm not trying to be mean, but you need to go talk to your broker, because I'm right. So go talk to your broker. Calls me back like 2 hours later, begging and pleading, because I was right, and he screwed up. He said, well, what am I supposed to do? I'm like, I guess you're gonna fix the $20,000 if they want done, or they're not gonna get the repairs, or they're gonna walk away and lose their earnest deposit, or they're gonna buy the house. What, you know, like, you figure it out. We're not doing any repairs. That agent ended up giving up all of his commission on a $1.3 million house to cover all the repairs that the buyer wanted. That was a very expensive lesson to learn, wasn't it? Okay. So, now we're gonna go through here, agency disclosure. So this is where you're gonna check mark, right, that you are a buyer's agent. And then your primary selling agent name, that's you. Okay. And then, of course, your email, right, so you're gonna fill that out there. So when they have a listing, right, you are looking at that seller's disclosure statement. You also have to have your buyer sign off on that. So it's asking you, have they received it? So you're gonna check mark that, and then you have to put in the date that is on the bottom of those seller's disclosure statements, and this is saying that they've received it. Now, there is a line down here that says seller is exempt from the requirements of the Seller Disclosure Act. We used to see that check marked a lot, because if you have an investor, right, they've had it as a rental property or a tenant occupied property and they never lived in it, then they wouldn't fill out the seller's disclosures. They would just sign it and put never lived in the property. We now have a different disclosure form for someone who's never lived in the property. But there are certain things that exempt them. If it's a trust situation, right, like mom and dad passed away, and the siblings now have to sell the home, they've not lived there in 30 years, they're not required to fill out seller's disclosures because they don't really know what the condition of the property is. They're just facilitating the sale. All right, lead-based paint addendum. This is very important right here. I'm gonna flip out of this purchase agreement for a minute. No, I'm not gonna say that. Okay, the reason I'm saying is in dot loop, and it's not in your KW North forms. I think it's under the Greater Regional Alliance, so I will have Tammy add these in. But we actually have a lead-based pamphlet. It's a really long pamphlet, but it goes through and explains everything about lead-based paint. Most people never give this to their buyer. Your buyer is going to sign a sheet that they are waiving their rights to have inspections done for lead-based paint. You are legally obligated to make sure that they get a copy of that lead-based paint pamphlet. So, what I do, and that's another one, I'm just waiting for somebody to get sued over, because it's gonna happen. Because something's gonna happen with lead, and they're gonna come back and go, well, I just automatically signed this because my buyer told me to, and they never gave me anything about lead-based paint. Don't be that person.
So if the property though is, say, built in 2001, do you still have to give them this?
You still have to fill out the top portion that says it was that it was done after 1978.
Okay.
But my point is, it should be given to them way beforehand. It's like when I do my strategy session, I send them a copy of this out of dot loop. That way I've got proof that I sent it, and they have it. Whether or not they read it is up to them, but I have provided them with it. Okay, so property description. We're gonna reference back over here, like to the listing card, and we're gonna see, because it's gonna ask, is it in the city, the village, the township? This one is in the city of Greenville. So I'm gonna check mark on here that it's going to the city of Greenville. And then it's gonna ask me county of, right? So for this one it's Montcalm, or it could be Kent, whatever. Commonly known as the address. So that's when I'm actually gonna just go right here and I will copy paste that and put my address right into there. So the next thing it's gonna say is following legal description and tax parcel ID numbers. So if we go back over here to the listing, then right here it actually has the legal description, see? Okay. Legal description and parcel plat are what the deeds actually go by, not the physical address. And sometimes you have agents that make stupid mistakes. So what I'm gonna do, rather than trust what's in here, is I am going to go to that realist tax info that we have, that tab that you have in the MLS. It's okay, Susan, we'll go back to it.
Okay.
So this is, Leah, I thought about you too when I was writing on this property, because look at the last name.
I can't even see it.
It's Ellen Boss. So if I scroll down through here, here is the actual legal description. And then here is the property ID number. So I will actually copy paste those out of here, because just in case the listing agent made a mistake when they put it in there, I want to make sure that it's correct on their purchase agreement.
Can you repeat what tab?
Yeah, go back.
Yes,
Yep,
that's what I was.
so if you're in the MLS, I'll show you right here. You go, see right here where you've got this little arrow at the end? When you click on that, oh, hold on, did I click the wrong thing? Oh, no, you gotta hit the more beside the arrow. And that's actually how you can access showing time. This one is the realist tax info. Okay, everybody got that? Okay, and then also I'm gonna take that parcel number or the tax ID number, and that's gonna go in right here. The next part, it says it applies only if the premises include unplatted land. There are very few that have unplatted land, but if you've got something like 10 acres, it could have unplatted land. I always just put any/all right there, no matter what property it is, just to make sure we're covered. What that means is that if the new buyer wants to subdivide the land at any point in time, that all those rights are now assigned to them.
So you write all in that?
Mm-hmm.
Okay.
Okay. Then we have our purchase price. That's where we're gonna put in our purchase price. And it asks for a dollar amount, see? And then underneath that, then we're filling it in like you would when you're writing a check. You're gonna spell it out underneath it. So if this is 350,000, we're gonna write 350,000 right here. And then you're going to spell, or, oh, it auto does it now, 350,000.
I can't see that well, but do you have like a decimal with zeros after it, or do you just do everything that goes before the decimal?
I just did it without, it, you don't have to have, some people do, some people don't, up to you. Okay. Now, seller concessions. What are seller concessions?
Like something's not included or.
No, those are exclusions.
Oh,
Closing costs?
Concessions would be like closing costs. So for instance, say, you know, your buyer needs 2% back from, right, the seller to help pay all of their closing costs. That is what a seller concession is. So, if I'm in dot loop right here, and I click on that edit text, it's gonna pull this button up, right? And I'm gonna okay, so notice when I start typing, it's gonna pull up clauses. Alright, so see this one says, seller to pay blank towards buyer's closing costs, prepaids, or other purchase related expenses. What these are, these clauses have all been run by legal. So it means if you use the wording that way, you're fine. There is also a tab in dot loop that has just like all the clauses written out, where you can look at them. But this is a great way to do it, because then if I click on this and I hit save, now it adds it in, and then I just have to go and put this in. Okay?
But not a DocuSign.
No, and actually DocuSign is going away, so I would recommend that you just go to dot loop.
We used to be dot loop, and then they said we're not paying for it, so then they made us go to DocuSign. And
Well,
oh my god, I'm gonna just strangle
through-
the offices.
Well, Keller Williams doesn't pay for dot loop anymore.
I know.
However, dot loop is included with your GRAR membership. That pays for your dot loop.
But not in Oklahoma, so they made us switch completely over.
Yes, I know. But I'm saying Keller Williams tried to make everybody switch completely over to DocuSign too, but DocuSign is going away. Learn dot loop. I'm sure there will be another system that will come out, and we'll probably all have to learn it then. But all of your mentors right now use dot loop. So learn dot loop. Yes, it's owned by Zillow now. That's why they all hate it. Totally get that. But guess what? Zillow also owns Flex MLS, and Zillow owns Sentry, and they own Showing Time. So they're still going to get whatever data they can possibly get. It's not gonna help you any. Okay, let's get down to terms. So, this is where we're check marking. Is our buyer paying cash? Are they getting a new mortgage? Right? What's going on there? But notice here at the top, we have our source of funds. And it says, if the property's value stated in an appraisal obtained by a buyer or a buyer's lender is less than the purchase price, the buyer shall, within 3 days after receiving the appraisal, renegotiate with the seller, terminate the transaction, in which case they get their earnest deposit refunded, or proceed to close the transaction at the agreed upon purchase price. Most people don't even read this and don't understand this is in here. That's what allows for that out. Because again, if we are getting a mortgage, right, the bank is going to value the property. And if the value comes in less than the purchase price, the bank won't lend more than what the appraiser says it's worth. So that is the condition there. Your buyer either has a chance to renegotiate, they can walk away and get their money back, or they can agree to make up the difference, right? It becomes like another renegotiation with the seller. But you have to do it within 3 days of the appraisal.
And you get that appraisal on Tuesday, day one starts on Wednesday?
Yep, within 3 days after receiving. But here's the thing too, remember, we don't control the appraisal. Who does? The bank. The bank controls the appraisal. So usually as soon as they get the appraisal back, they're going to let you know. But you need to stay on top of it, right? Okay, but it does say within receipt of the appraisal, but you don't wanna be like 5 days from closing and you're just getting the appraisal back and it comes back low. So stay on top of that, make sure you're getting it back from the bank. Alright, so cash, it's cash. Let's talk about the important differences here. If you have cash and there is no lender required, you can technically close in 2 weeks. You're gonna have to provide proof of funds with your offer for them to do that, okay? And then they also have to order title within 5 days of the effective date. You usually wanna order it sooner.
Right.
Okay. What else is different about cash?
I wonder,
King? Cash is not king, which is what most people think in real estate, but it is not. Okay. No appraisal, right? We don't have to have an appraisal. If an offer is cash, the seller gets to choose title. All the title work is done by one title company on a cash transaction, and the seller gets to pick who does it.
So the seller has to order that title within 5 days?
Both sides have to order title. Buyer and seller both have to have their own title on every transaction.
But the buyer has to go with who the seller said?
Yes, yes, so.
And why is that?
Because if there's cash, there's no mortgage involved. So, it's a completely different process. It's basically just, researching the deed, right, and then preparing the documents to change that name over.
Why does the seller, like, why does it matter who they choose? Like, why does the seller care?
I actually don't know.
So weird.
It's just, that's the way it is. If it's a cash transaction, the seller chooses the title company and everything is done by that one
Maybe it
title
just
company.
simplifies it?
It could be, because again, there's not the same requirements
Right.
that you have to go through a mortgage process. It's
Huh.
basically just transferring the deed.
Right,
So, but that's something that's different.
okay.
Okay, so new mortgage. This is where we're putting down the full purchase price upon execution and buyer's ability to obtain like what type is this, right? So say it's a conventional mortgage. And then like how many years is it? You know, is it a 15 year, is it a 30 year? In the amount of blank percent of the purchase price. So if your people are putting 5% down, then they're obtaining the mortgage at 95% of the purchase price. Okay, at an interest rate not to exceed. This is important. I've actually seen people not fill this out too. Okay? Let's say that at 6.5, your buyers are fully qualified to purchase this property. But if the rates go up to 7%, they can't afford it anymore. Unless this is filled out, that does not give them an option to back out without losing money. So that's where I'm going to put in like 7%. If it goes over 7%, right, on or before the date that the sale is closed, then my buyer has a chance to walk away from this contract because they can no longer afford it.
So they're approved at 6.5, but somewhere along the line, the rates go up to 7.5, we're out at 7.
It's really weird with rates, and I am not a mortgage expert, so I'm gonna say we're gonna consult that. But when you get pre-approved, they do not lock in your mortgage rate, right? You get a pre-approval. You only get locked in usually within 3 days of submitting the purchase agreement to the loan officer. So let's say when we got pre-approved, when we made the offer today, they're at 6.5.
Right.
But I don't get final signatures on it until tomorrow, and tonight the rates all of a sudden jumped up another 0.5% because something happened.
So then
my people are still locked in.
say, we put 7 in here and it's at 7.5, so we can get out of this.
Yes, you can get out.
Okay.
Yes.
And get
your earnest money back.
Okay.
Yes.
So it terminates the contract then, right?
Basically.
With
It
the-
doesn't
the
necessarily
purchase-
terminate. I mean, if your buyers are scrimping and blah, 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 and they say that we'll take a second job because we want this house so bad, then fine, proceed.
Okay.
But it gives them the out if the payment jumps to what they can't afford.
Well, I was wondering, does that allow now the seller to look at a different offer? if
Yeah.
this happens.
If we cancel a contract, then yes, they can go right ahead and take another offer.
Okay.
Okay, so that's where we're filling out there. Then it says, right, that the buyer, that we have to apply to the lender for our application within so many days after the effective date. Usually we put 2 days on there. That's the next line item after we did that 7% per annum. What this is you're saying, yes, we will send all of our documents to the loan officers and start our mortgage application within this number of days. Right, and you wanna be very fast and proactive in doing that, cause if they need 30 days to close, you need to get that to them as quickly as possible. Okay, then here, like buyer will agree to pay an amount not to exceed blank representing repairs required as a condition of financing, not inspection, financing. The reason we see this a lot of times is on a VA loan, right? Because VA sometimes has some stuff that you know is gonna get called out. Let's say the house is missing handrails on all the stairs, and we know that the VA appraiser is gonna call that out. Well, if the seller doesn't wanna have to deal with it, then the buyer can check mark right here that they'll pay an amount like not to exceed $1,000 to cover any repairs that are called out by that appraiser. And basically, it's just a way of assuring the seller, saying, hey, we know that those are gonna get called out the same as you, and you don't wanna have to deal with them, so we'll be willing to pay to have those installed, because it's not a condition of conventional financing, right? So if they had a buyer with a conventional offer, they would not have to worry about the handrails, because it's not a condition of the loan.
So if it's not a VA loan, we're not filling this out, or we are anyway?
If it's a conventional loan, you're never check marking that box.
Okay.
But if you have a VA or an FHA or MISHDA or one of those loans, again, the appraiser has the right to call out certain things that are considered safety issues. And the seller is required to repair anything that gets called out as a safety issue before they will fund the loan.
So if the buyer agrees and it's $1,000, that gets added to their mortgage, if they don't have the cash up front or something?
No, the buyer has to do it. The property cannot close unless it's done,
Oh, I see.
because the appraiser has to go
So
out
that
and do
has
a
to be something
re-inspect.
they need to keep in, yeah.
Yes.
Okay.
Yep, okay. And then that second thing that we're check marking right there, buyer agrees, that is authorizing you to obtain information from the buyer's lender regarding financing and anything else. So that is what allows you to talk to the bank, right, about anything you need to talk to the bank about
So they should
throughout their
always
loan.
check agrees.
Yep. Okay, we're gonna skip seller financing, cause that's extremely rare. And equity, and the other. Okay, now, is contingent upon close, is contingent upon the sale and close. The top one is not contingent, that means your buyer does not have another property that they need to sell in order to buy this one. Right, they're first time home buyers, they live in an apartment, they don't have to sell anything, we're buying the house. Okay, is contingent upon closing. What this means is your buyer has already got their house on the market and it's already under contract. So that's where we're gonna check mark the contingent upon closing, and then we're gonna put the property address in here. Now normally, if you're writing an offer and it's contingent upon closing, you're going to send a copy of that purchase agreement and everything on the house that's going to close, to the agent as well. They wanna see it. They wanna know it's under contract, they wanna know what the terms are, they wanna know where you are in the process. Okay, number 3 is contingent upon the sale and closing. What that means is, yes, we wanna buy our new home first, then we'll put ours on the market and see if we can get it sold. So this is, Russell, you love this house. We've got most of the stuff done, but you said, I can work my butt off and I can have my house ready to go in a week. Then we're gonna check mark this. We're going to list where his house is, right? And then what we have to do is we have to say what time we're gonna have it sold by. we can't ask that seller just to wait indefinitely for us to sell that house. So, you know, if we want it sold, and we want it sold yesterday because Russell wants this house, then we're gonna price it very aggressively and hope that it sells within a week, and it's gonna take 4 weeks to close. So I'm probably gonna give us 6 weeks, right, to honor before we get that closed. And again, as a listing agent, if somebody writes me an offer and it's contingent upon the sale and closing, I am going to call them immediately and say, what is your game plan for when you're going to be on the market? Right? What price point are you going to put it at? Because I want to make sure, again, if I look it up and run a quick CMA and I think the house is worth $350 and they're going to list it at $399, I'm advising my sellers not to take this because the house ain't never going to sell at $399. Make sense? Carrie, got a
Yeah, I'm
question
just
about
reading the
that?
rest of it.
Okay,
Yeah, sorry.
that's okay. All right, does everybody understand then the
See my
difference
brain.
between contingent upon close and contingent upon sale and close?
Yes.
Okay.
Question?
Yes.
With the contingent upon sale and
Yes.
close, are there, places to note, like if another offer comes in, you can get booted out? Or is that a thing?
Yeah, and there's been a lot of talk about the legalities of some of that around it. So some people will ask you to actually stop marketing it, right? Like actually take it pending on the MLS. I'm not doing that. One, it's not pending, it's not under contract. Let me slow back up. Okay.
Yeah.
If we are contingent upon closing, then I can legally go pending by accepting this offer. You know, and if they're set to close in 2 weeks, then there's a reasonable likelihood that they're going to be able to follow up and to buy this home. I'm going to stop showing it to the other people. Now, if it's contingent upon sale and closing, it does not go pending. Because this contract can't start being executed until this one goes under contract. And I am not going to stop marketing it to anybody for that. Now, what you can do is when you accept the offer, right? You can say that like the seller will give the buyer a 48-hour right of first refusal if another offer comes in. So basically what happens is I call Russell and I go, Russell, I'm so sorry. You know, like I know you really want this house. It's 2 days after we got our offer accepted. Somebody else has offered them. Same thing, no contingencies. You know, if there is no way that Russell can buy this home without selling his first, then we're just going to have to release that and let them take the next buyer. If Russell's dad pops in and says, "It's your dream home, son, I got you covered, you can pay me back. I'll fund what you need to get to the closing table," then we're going to enact that and say we are removing that contingency from the contract. Let's go.
Would this be a place that you're accepting backup offers? Or where does a backup offer come in?
Most of West Michigan does not do backup offers.
Okay.
Some agents do accept them. They're what I call the Wild West agents that you find down in like Kalamazoo and Battle Creek and that kind of thing, but we don't in general. So what I would normally do is if something happened, right, and my contract fell through, rather than having a backup offer, then as a listing agent, the first thing I'm gonna do is turn around and notify everybody who was in the property again that they have an, you know, our offer fell through. Are they still interested in joining?
Okay.
So,
Oh, thanks Trish. Yes, I will try to do better.
so in this case, if you're a buyer's agent, are you offering like some sort of massive earnest deposit? Like, what incentive does the seller ever have to even do this?
You can.
Like, hey, I'm willing to give you $20,000, just save this for me, I'm gonna sell this house in 2 weeks.
You could, you can do a non-refundable earnest deposit. There's all kinds of ways around it to entice the seller, and that is for our offers and negotiations class.
Okay.
So I'm gonna take us back here, cause we're gonna be really tight on time.
Okay.
Okay, so now let's get down to this one too, fixtures and improvements. Okay, so this is the part where you're going to look at the MLS on your card, and you're going to see, like right here, if it's under the appliances list, or if it's under the additional items list, then those are things that they are including in the sale of the home, okay? So I'm gonna flip back here. This is the same list that the seller's going to have, and it basically says, it's not all inclusive, but it's intended to be a big list of what's going to come with the property. So, it includes all the following: all buildings, landscaping, attached smart home devices. If they have a Ring camera, unless you reserve it, it stays with the house. Attached security systems, lighting fixtures, and their shades and bulbs. This one was written in because like 25 years ago, some guy went through and removed every light bulb out of the house before he turned it over to the buyers. Yeah. Ceiling fans, hardware for draperies and curtains. That's important. That's a question I get a lot too. So you have to leave the curtain rods. They can take the drapes if they want them. Okay? Your seller can take the drapes. All right. Window shades and blinds are automatically included. They're screwed in, they stay. Built-in kitchen appliances, including garbage disposal and drop-in ranges, wall-to-wall carpeting, all attached mirrors, all attached TV mounting brackets, all attached shelving, workbenches, stationary laundry tubs, water softeners, water heaters, sump pumps, water pumps, heating and air conditioning equipment, window units excluded. Right? If you have one of those little ACs that goes in a window, that is not attached to the house. Doesn't have to stay unless you ask for it.
So if we have a TV mounted, we have to leave the mounting?
Yes, ma'am, sure do. It used to be either or. Like either if you left the mounting, great. If you took the mounting, you had to repair the wall behind it before you could turn it over. At that point in time, nobody ever wanted to fix the wall. Everybody just left the mounts. So it got revised.
A little easier.
Mounts stay. Heating and cooking fuel tanks, fireplace screens, inserts and grates. Anything that goes with an in-ground pool. Screens and storm windows and doors, awnings, installed basketball backboards, poles and goals, mailboxes, flagpoles, fencing, invisible in-ground fencing, and all related equipment, including collars. That didn't used to be in here either. If you had an invisible fence for the dog, we had to ask for the collars. Now they're required. They have to stay with it. Okay. Underground sprinkling, installed outdoor grills, all plantings and bulbs. That's a big one too. You do not realize how many houses you're gonna have where there is a rose bush in the corner that was great grandma Sadie's, and they want to take the rose bush with them. It's like when you're listing it, you have to exclude the rose bush, and you have to make sure when you accept an offer that the rose bush is excluded on the offer. Okay, so that's a big one. Garage door opener controls, any other items that are permanently affixed to the property, but also includes. Now, even though this says kitchen appliances, CYA. If you want it, put it on there.
And
So
make sure
I do not
tells you that it's written on there.
Well, here's the thing too, right? You could say all kitchen appliances.
What does that mean?
Let's say that my seller had a brand new $5,000 refrigerator that they're absolutely in love with, and they want to take it with them. And the thing just says all kitchen appliances. Didn't say all kitchen appliances at time of showing.
Right. They installed some piece of junk.
They go buy a piece of crap refrigerator, take the one they want and put that in, and they're still legally within the contract because it is the refrigerator kitchen appliance.
So you can even take a picture of the serial number and write the serial number in there of the actual appliance.
So I specifically spell out microwave, refrigerator, dishwasher, stove, blah, 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 as seen at the time of showing.
See, why, hey,
You also need to make sure, like, let's say that there's a, you know, we're Midwesterners, there's a fridge in the garage. My buyer wants it. It's not mentioned anywhere, ask for it.
we lost our freezer, our upright, because the agent
Didn't catch it.
show it,
Mhm.
you know, when we went over it, which our fault too
Yes.
for not
Right.
I had
reading
no
every
idea.
line.
Okay, but personal property, and this is why this is interesting, what I wanted you to see on here. So in this one that we just bought, I know this is hard to see, but it actually included, where does it say right here? Yeah, theater seating and with 6 full leather media chairs and TV remain with the home. Okay, the 6 media chairs we really liked, we're keeping those. The TV we're not, because it's one of those, it says 70-inch, and it sure is, but it's one of those old bulky 70 inches that are like this, that they just don't want to get out of the basement. We're not being responsible for that. So we said, thank you, we're going to take the theater chairs, but we're not taking the TV. You have to take that out. And I made that clear with the agent when I submitted the offer too. Please note, in the do not include, we do not want the TV. You have to remove the TV. Okay? Yes? No?
Yes.
Yeah.
Okay, and when we get to listing, we're gonna skip over this portion, because we just went through it so thoroughly here. But you need to remember that when you're putting what's included and not included on the MLS, you better reference that and make sure you get it right.
So let's say that they're excluding that, rose bush of Aunt Sadie's,
Yes.
Grandma Sadie's,
Yes.
whatever. But we don't want that hole there. We could, in our offer, put
You
the-
could take
and
the
try-
rose bush out, right, and fill it in, and then you don't have to mention it at all. It does not have to stay with the property at that point in time. But if it's still got roots in the ground at the time of showing, then you have to do that. And you wanna be very cautious, excuse me, cause you're gonna end up with some weird funky ones that are going to be requested, right, that people wanna take with them. I've had ones where they had, you know, a Tiffany lamp, or a Tiffany, light fixture installed, right, in the dining room, and they're taking the Tiffany light fixture, and it's gorgeous, gorgeous. And you know buyers are gonna fall in love with it. Okay, we got 2 ways to play this. Either one, yes, I want the buyers to fall in love with this house, and that's gonna be a big portion of it. Yeah, I'm gonna leave it up, but I'm gonna make sure it gets excluded. But there are other times when I go, if you want that bad, it's coming out before we go on the market. Like, you just get it out of the house before we go on the market.
And replace it? Or
Yes.
just get it out of the house?
Yes, and replace it.
Okay.
Yes.
This is on the buyer's side. You
Yes.
have to say does not include Grandma Sadie's, Aunt Sadie's rose bush, because it was in the MLS. You have to disclose it here and on the seller side.
So if I'm representing the buyer, we looked at the home, we're
Yes.
doing our purchase agreement, we're buying the property,
Right.
and the listing told me that Aunt Sadie's rose bush was excluded.
Yes.
Then I'm going to write in, but does not include
Okay.
Aunt Sadie's
Okay.
rose
Yes,
bush.
we disclose there too. Okay.
Yes.
But you could
Aunt Sadie's
also
rose bush.
conversely put it in the other line too, like,
You could, where they get to keep it and all, but here's the thing too, do you really want buyers and sellers getting mad at each other and not wanting to work
No.
together over Aunt Sadie's rose bush? Give them the
No.
dab blame rose bush.
Yes, exactly. It can be replaced.
I had this conversation with Russell, if I may, last week, because he has sellers and like she likes her curtains. She wants to take them with her to the next house. But I think the buyer was wanting the curtains. And I pull up the thing and I look and I'm like, they're Target curtains. That's like $80 a room, right? If the offer is a great offer and it's what you want, leave the curtains.
Right.
So when I'm meeting with my sellers at the very beginning, I'm having that conversation too. And I even ask, like, is there anything super important when we're talking about the fixtures that are affixed that you have to take with you? Because again, if they absolutely love the curtains that are in the living room, take them down. We're putting Target curtains up before we get the picture stuff.
Yeah.
Easiest way to do it. Then you don't have a fight over 2 people who are now in love with a $150 set of curtains.
Black Friday deal going wrong.
Right. Just like when you're looking at houses with your buyers and they're going, I don't know if my couch would fit right there. We don't buy a house based on your couch. right? $350,000 purchase, $3,000 purchase. Let's find you the right house, and then we can get you a new couch if we have to.
Yeah.
Okay, yes, questions? Doing okay on that?
Yep.
All right, let's keep going. Heating and cooking fuels. This is where, if they have a propane tank, right? So if it's natural gas or something like that, this doesn't apply. This is our more rural areas with a propane tank. And this purchase agreement states that the tank has to be at least 10% or higher when we turn it over to the buyer. Okay? But let's say that your buyer wants the tank completely full. You can still ask. Doesn't mean they're gonna give it to you, but you can ask for it. So you could put on here, you know, fuel tank to be filled to 100% capacity by closing. If you don't have it, then we usually just write in our NA, not available. Okay, assessments. What is an assessment on a property?
Like
Some
taxes?
improvement on roads, yeah.
Yes, taxes is its own section.
Okay.
So assessments are like when they ran sewer lines and everybody had to come off of septic and hook up to sewer. Frequently they'll do like 10 years or something for that assessment. So for instance, with where I live, the township or the county is redoing part of the watershed with the drains, right? I think there's 6,600 households that were affected, but the assessment came out to about $600 per household. And we were given the option of paying it all in one lump sum or stretching it out over 5 years, and it would be included with your winter water and sewer bill every single year. Of course, they added interest and fees on if you were gonna stretch it out over the 6 years, right? But that is an assessment where you had that many years to pay it. So this is saying that the seller has to pay all assessments that could be outstanding before you transfer the property, or seller shall pay all installments that are due and payable before the day of closing, and then the buyer takes it on.
What one is more common?
It's more common to make the seller pay for any of it that's out there. And you're not gonna find a ton of them. We used to get a lot more when they were first starting to put septic into a lot more of the, like even down Cascade Road, parts of that still don't have septic service.
You mean
And-
sewer?
Yeah, sorry, sewer service, they're on septic. And for a while, like Cascade Township, for 2 years, they actually had a law passed that if the house was changing properties, you were now forced and required to hook up to the sewer system. And that could be $10,000 to $15,000, right? So now that is something that has to be paid, and you have to figure it out. Okay. You can also find out if you go to the BSNA software, which we'll look at again when we're getting ready to do listing. It usually tells us if there's any outstanding assessments on the property, not always. Okay, now we get down to our property taxes. So with property taxes, it's either no proration, right? And either you're asking the buyer or the seller will pay the summer or the winter tax bill, calendar year proration, or fiscal year proration. The normal one that we use for most transactions is going to be calendar year. So with calendar year, what they do is they take the tax bill for the year and they divide it by 365 days and they get a daily rate. And if the seller owned the house through June 1st, then they figure out how many days that was, say 180. They multiply it by the daily rate. That's how much of the tax bill they're responsible for. If they've overpaid, they get a portion of that back. If they've underpaid, they have to pay in. And then your buyer gets charged for the other 180 days of the year. Simple? Understand?
Yes.
Yes, okay. So, fiscal year proration is different. City of Grand Rapids does operate on a fiscal year. And they operate in advance. So what that means is they are actually collecting the money for the following year up front. So in this case, if you are in the city of Grand Rapids and you check marked calendar year proration for your buyer, that's fantastic because the taxes have already been collected a year in advance. So now the seller's already paid it all, your buyer ain't paying any, or very, very little.
And they have to catch that?
You have to catch that, you have to know.
Well, I know, but what seller doesn't see that?
They don't know. They don't know what the tax proration is.
Oh.
It's up to their agent to
Right.
help them do that. So again, like if I was the listing agent,
I'd be looking.
I'd be looking.
Yeah.
Right. But you would be surprised. I mean, most agents do not know about this. These guys that have been here for a few months now, they know, they've heard me talk about this several times. But you cost your seller money every single time. You list a home in the city of Grand Rapids and then you accept a calendar year proration on the purchase agreement.
So if
Now
you're,
I'm going
you're an
back.
agent that catches that, then would you have to do like a counter offer?
I would do it
Damn
as
it.
written, as we're gonna get down here to the last
Okay.
page. We're gonna do an as written accept and we would say fiscal year proration. Yep, for taxes. Okay.
That's a good tip.
Well and septic, let's keep going here. Yeah, you should have seen the look everybody gave me the first time I brought that up. They're like, you're crazy, and I'm like, no, I'm not. And then here came the title company up front going, she's right. Oh. Okay, if it has well and septic, within 10 days after the effective date, what's the effective date of a contract?
The day after the signing. It begins one day after the purchase agreement is signed. Or
Not signed, returned.
returned.
Right. So once
Sorry.
you wrote this offer, right? And then the buyer has accepted it. So if they've accepted it, that's great, but they have to notify your agent that they've accepted it. Like they have to return it to you. Okay, so then that begins, the effective date is the day after. Okay, so this is where the buyer or the seller can arrange for, at their own expense, an inspection of the primary well used for human consumption. When they do a well test, they check the pump, they check the motor, right, that kind of stuff. They do samples from inside the home and they do samples from outside faucets too. And then it's sent off to a lab to check for the nitrates and that type of thing. These contracts, back in 2021, 2022, a seller had to complete well and septic. And it had to pass all the inspections before it could change hands. Now, the buyer or the seller can pay for it. It's not a requirement on the seller anymore.
Does it have to be done at all?
It depends on the county. So you have to check with your county. And every county or municipality is different too. Like here in Kent County, it's not a function of the health department, right? Like Charlie West does well and septic. In some counties like Oceana, it is the health department that does these tests, and it has to be scheduled through the health department to have it done. So again, it's different, every county, every township.
What about cities?
Most of the, again, depends on
See, I'm in
county and
GR.
township.
I don't think this happened.
Well, nobody in the city of Grand Rapids is on well or septic, they're all on public utilities.
I got you, yeah.
Right. This is only if you have well and septic. Okay, it has to be informed or performed by a qualified inspector in a manner that meets county or other local government authority protocols. Okay. If the report discloses a condition unsatisfactory to the buyer or doesn't meet the county standards that are a condition of the sale, the buyer may, within 3 days of receipt of the report, by written notice to the seller, terminate the agreement and get their earnest deposit back, or make a proposal to the seller to correct the unsatisfactory conditions. If the buyer fails to make a written proposal within the reference time period, then we are deeming that they have found that report acceptable and we're moving forward. Okay. Does this mean, because too, it says that the buyer can ask the seller to correct the unsatisfactory issues. Does that mean the buyer can't pay to have it fixed?
The buyer can.
The buyer can. Does that mean the seller has to pay to have it fixed? Nope, not anymore. So that gives everybody an out, and they decide what they're going to do.
What does that written report look like if they like wanna get out of it? Is that like a standard form that you just send to them to terminate the contract?
If you wanted to get out, then we would send over, an addendum, right, or a cancellation, notice of cancellation of the contract. So, but it does happen sometimes. Right? I mean, you do have septic systems that are failing.
Yeah, it's expensive.
Before you send
Well, you think it's expensive, but overall too, if you took 20 years
Right.
of what you've been paying for septic services versus what it costs to replace your septic system, right? It's just you're hitting it all in one lump sum.
But before sending over the cancellation, you could go back to the seller and say, hey, we found this, are you willing to help negate the cost? I mean, you could go to them.
Oh
right?
yeah, you're not just gonna immediately cancel it, you're gonna try to find a way to fix it, right? So they can get the house, but it gives you an out. Okay. So, there's that one. Okay, we'll do the last part here too. So if the seller fails to respond or to arrive at a mutually agreeable resolution within 3 days after, buyer has 3 days to provide written notice of termination, go Aubrey, of this agreement and receive a refund of their earnest deposit. If the buyer fails to terminate the agreement within that 3-day period, then we are assuming that they have accepted everything again and we are moving forward and buying the house. Now, they can also check mark here to waive their rights under this paragraph, and that didn't used to be allowed. But remember, it depends on your county, your township, or what the rule is there. So in Oceana, you cannot waive it. It has to be completed. They require that septic system be inspected prior to a house changing property or changing names. They do that as a safeguard, right, to try to make sure that all the septic systems are in good shape. And that's one way to help do that. So if the local ordinances supersede that, somebody has to have the well and septic tested. Questions?
I don't think we have that part on our paper.
It's the top of the next page.
This is, under inspections, this means inspections, like this could be foundation, this could be.
Let me see what yours, maybe the pages are messed up here.
So we went from well and septic to inspections,
Okay.
investigations,
Yeah.
and now we're on this page.
Okay, 16, yeah, I guess okay.
It's okay, you just scroll down a little.
Yeah, you
I
can
think
go
I did,
faster.
didn't I?
You have
It's
it,
there.
you just,
It's right there.
Okay.
yeah, see,
Oh, sorry, I did, I scrolled too
No, it's
far,
all
my
right.
apologies.
It's basically the
Okay.
same thing, just different type of inspection.
yeah,
This is the home inspection.
yeah.
Sorry,
Okay.
I did, y'all, thank you for keeping me on my toes, I got too trigger happy there. So this is the investigation for the house, right? This is the time frame that we're gonna put in, within so many days after the effective date. So you can pick, our contracts used to state 10 days. Now we get to write that number in. Why would you wanna do a number that's less than 10 days?
Speed it up.
Sweeten the offer.
Yeah, speed it up, sweeten the offer. It's less time, right, for people to be, for sellers, if something's gonna fall through, it's less time off the market for them to have that done. All right, so that the buyer has the right to inspect buildings, premises, components, and systems at their expense. Any damage, misuse, or abuse of any portion of the property that results during the inspection is the buyer's responsibility. And this will happen, so be prepared, because I had one of the weirdest ones ever. So I had a buyer who, during the inspection, had noticed that there was something kind of like that looked cloudy in the oven door, right? We all know what, and oven doors do come off, right? They have that little hinge and they come right off. So decided, like, I'm in the other room with the other partner, spouse, whatever, looking at something, that they were gonna check something with that oven door, went, took it off, then dropped it. So it shattered the oven door. Now, thank goodness, the people had already moved out on this property, right? And we were going to proceed. We got through everything. So they were just going to replace the stove and oven with whatever they wanted to buy. But otherwise, if something happened and we weren't proceeding, we would have been responsible for fixing that. Okay? So be careful. Inspections do not give you the right to pull up carpet to see if there's hardwood floors under it. You may not damage the home in any way while you're there. Okay. Also, whether or not we're in a flood zone, this is also when your buyer should probably be calling for their insurance quotes. Or especially as the inspector is wrapping up, because they're gonna ask questions, right? About like, what's the age of the roof? What's the age of the furnace? What's the approximate square footage? What's the blah, blah, blah. Good time to do that. You have to have everything completed within that time frame. And then you can go back to the seller and ask for repairs, or you're deeming it at, acceptable as is, whatever you're gonna do that you work out with your buyer there. Questions on that? What if you can't get everything completed in that time?
Accept it as is.
You can ask for an extension.
You can ask for an extension, right, but you have to get it in writing before that time frame expires. Okay?
Yes. What do we put for the subject property address? Is that just the same address we've been talking about?
It's whatever the address is at the bottom of every single page. And I will show you a trick later. When I said like don't autofill all that stuff, there are certain things that you can autofill, like the address, and then dot loop will go ahead and put it back in. It'll put it at the bottom of every page. But if you're handwriting it, you have to write the address at the bottom of every page.
Okay.
Okay. We good with that page?
We're good.
All right. We're almost done with this one, and then we're gonna get to lunch. Okay, so that, yes, here, that is where if you're not doing an inspection, you would waive that.
Which is not a good idea.
No. It's never a good idea to waive an inspection. And we went through about 3 years of real estate where you weren't gonna get a house if you did do an inspection.
Yeah.
That was the reality of what we lived in. 35 offers on every house, you're not gonna get an inspection. Some states, Massachusetts right now has passed a law that home inspections may not be waived. They can't even have it in their contracts anymore. It's not the real estate professionals that got that passed, it's the insurance companies. Eventually it will happen here. It still laughs at me. If it started in one, it'll roll down to the others. And it has nothing to do with us. It has everything to do with the lobbyists for the insurance companies. But I think it's a good thing. I mean, you should have to have an inspection. Buyers should know what they're walking into.
Have you ever done like the, pre-inspections, mini inspections?
So, it depends on which side of the fence you're sitting on, right? If I'm a buyer's agent and they've done a pre-inspection, that's fabulous, right? I'd love to see it. It gives us a good opportunity to make our best offer, knowing as much as we can about the house. On a listing side, if you do a pre-inspect and you find something really big that's wrong with the house, you now have to disclose it or fix it before you sell it. And I prefer not to do that.
I guess I was asking more for the buyer's side. Like
Right.
any type of-
Yeah, I mean, if they've got one and they provide it, fabulous, right? I'm thrilled. Yep, let's look it over, let's see. And doesn't mean that I probably still wouldn't do my own inspection after that. The inspector would not be biased. I mean, they're gonna find what they're gonna find. But still, I would want a different inspector to make sure after that. Okay, questions? Any more questions on that portion? We really gotta keep moving, cause listing side is way more complicated than this. Okay, title insurance then, we have to do within 10 days. Again, if you wanna close within 30 days, you need to have your title policy ordered within 2 or 3 days of going under contract. When you order title, it will be an expanded coverage policy. Why do we get title insurance?
So that you know that you have the right to the house and that it doesn't have any shady background.
Yeah, that no one else has a claim to the property. What else does title insurance do?
Assures that the seller has paid off any outstanding liens.
Yep, it ensures that there's no other outstanding liens or debts against the property, right? And that's one of the biggies. Title companies who shall not be named here in GR that I can't stand, that have done really poor jobs. And I've had properties where, maybe it changed hands 15 years ago and they did the closing and we find out there's still an open lien against the property. Right? Or that there's still somebody who has an open claim that was never dismissed against the property. Title matters. And title is there to protect. So if an issue comes up 2 years later in XYZ with your property, then your title insurance kicks in to help solve and resolve that property. And I've had to pull TransNation in more than once to help fix something, and they will do it, and they get it done. I had a home, this one was 9 or 10 years back. This was John and Holly's place. They had bought a new build directly from a builder. And then they were getting ready to build another new house. So we got everything under contract, we got that house built, now we're gonna go sell the home they live in. That builder had went bankrupt and was out of business. The title company that he used was out of business, and the builder still had a $75,000 open line of credit out against the property. Now, it had a zero balance, so that wasn't a big deal. But it's like a HELOC, right? A line of credit against the property. And now the builder company no longer exists and the title company no longer exists. We can't get anybody to certify that there's no money owed on this $75,000 line of credit. Took title an extra 3 weeks to get that one fixed, but they did.
Because they're liable, right? If they make a mistake?
No, because they had not closed on this property before.
I see.
The builder had his own title company that had also collapsed and closed. So, it's like, okay.
Yeah, what do you do? Yeah.
Right, you don't wanna have to deal with any of that either. That's wonderful for title. Okay, now we have our property surveys. The buyer, you can ask for the seller to pay for it, you can elect to pay for it, or you can choose not to have a survey. Most people, if they're not getting one, will check mark no survey, and then they'll write in, like buyer would love to have a copy if there is an available survey. Or, buyer deems seller provided survey. I can't think of the word. Acceptable. Thank you. Yeah.
Okay, so what's regular in this portion? What's the most common way to do this for the property survey?
There is a no common way.
Oh.
That's up to your buyer, right? You don't make that decision for them either. Do they want a survey, yes or no?
Right.
I'm going to tell you right now, unless it's 25 acres and it's not been surveyed in 80 years, the sellers are not gonna pay for you to have a survey. Especially if it's in like a neighborhood or something. Surveys on average are $750 to $1,000. And again though, if your buyer has specific things that they're looking at, like they want to put in a fence, or they want to have a pool in the backyard, right? Those types of things. There are setbacks, right? From township, from city. So I would highly suggest that they get the survey and make sure that they can do that if they want to. There are some places where you have to have a certain amount of land if you want a pole barn that's over this number of square feet. You do a survey. Okay, home protection plan. Okay. we are gonna spend a few minutes on this because nobody ever does, and I think it's important. Are home protection plans worth it? Somebody tell me, come on, you gotta have some kind of expense.
Depends on the situation.
Yeah.
Yes, yes, depends on the situation. All different kinds of thoughts and processes on that. There it is. Hey Terry. Okay, these are also in dot loop, but we've only got like 4 of them sitting around here. So I'm gonna put one kind of like per area, and you guys can kind of take a look at those. All right, I'm gonna put one over here with you, Aubrey, with Jason, or Jada and Leah. Okay, so home protection plans have different levels. They have different variables of what they cover, what they don't cover. They don't cover roofs. Okay, so keep that in mind. Does not cover a roof. And this sheet right here, you actually have in your packet that I gave you to look at. I'm sorry, Trish, John, I know you guys can't see this, but it's the America's Preferred Home Warranty, like acceptance invoice or waiver sheet, if you want to look at it. So we are affiliated, right? An affiliated business with them. So every client, you have to have that affiliated business disclosure signed, and you're either accepting it or you're waiving it. I do not fill out all their information up here if we're going to waive. The only thing I fill out at that point is their name and their address. Okay? If we're buying one, then I'm going to fill everything out so that they have all that information. They are currently doing a thing right now. They come in and visit with us right in the office. They have a new concierge program where they're reaching out. They're helping your clients, like with transferring utilities and that kind of thing. They are being your very good friend and helping you stay in touch with your clients for the next year, regardless of whether they have a warranty or not. So it's somebody really, really great to have in your corner. But you can see it has different plan options, right? So for a single family, regular house, it's a 1-year plan, is $499 and has a $100 deductible. So if you're looking right here at that buyer plan, then it will tell you what's included. So the coverage items are built-in dishwasher, microwave oven, central air, central vac, ductwork, concealed plumbing or electrical. So again, like you can't see behind the wall, right, on an inspection. The exterior water and sewer line, garage door openers, heating system. It has hotel benefits, like if you have to go out of your house for a week. The refrigerator, plumbing, a roof leak repair. Not a new roof, but a roof leak repair. Washer and dryer, water, and water well pump. Then they have all the add-ons that you can do over here. So they can ask to have the seller pay for a home warranty.
Didn't even know that existed.
They can. Doesn't mean they're gonna get it. They can ask for it. You can also put in here, like, like buyers choosing to purchase one for themselves. So here's the great thing about the home warranties though. If your buyer is choosing to pay for one, right, fantastic. It won't kick in until the day of close, but it doesn't get paid for until close. So it's not out of pocket. It gets rolled into the closing cost, and then it's good for a year. On the seller side, I have used this to save my seller's butt many, many times. If we sign it when we're listing the house, even though we don't pay for it until closing, it kicks in and covers my seller from that day that we go on the market. So let's say that my seller has a home where the furnace is 22 years old, the hot water heater is at the end of its life, everything is getting really old. Then if something happens during that transaction, like let's say we're a week away from closing and the furnace goes out, this kicks in. They pay the deductible and it covers the rest. And it stays with the buyer or a year. So I frequently encourage my sellers, if we have a whole bunch of outdated stuff, let's offer the 1-year home warranty. One, it's gonna give the buyers a little bit more peace of mind, and two, it's gonna cover you if something goes out during the transaction. Because if our seller's disclosure said that the furnace works, and they bought this home and the furnace goes out before we close, they have to buy a new furnace. $499 is a whole lot cheaper, right? And there are times when I use this for my clients. So the one that we were just looking at there, 212 South Hillcrest, it has a metal roof. It's like 5 years old. That metal roof's gonna last a long time, so that's great, love that. But a lot of the other stuff in the home is dated and older, and I don't know what kind of lifespan it's got. So for my closing gift for those clients, I will also be buying them a home warranty. Okay? Okay, questions on the home warranty? Okay. Yeah. Pre-closing walkthrough. This is where you are reserving the right or waiving the right to conduct a final walkthrough of the property. It has to be within 3 days of the scheduled closing date. What you're doing is you're making sure that everything is in the condition that it's supposed to be in before you close. Should you be doing a walkthrough? Yes, you should. And are there times when that walkthrough is still not going to be helpful? Yes, there are. Let's say that the seller has possession 45 days after close. Right? They can still do damage to the property, but that's what that temporary occupancy addendum will cover if something like that happened. But you need to make sure that if they said they were leaving stove, refrigerator, and microwave, that the house still has a stove, refrigerator, and a microwave. You need to make sure that they didn't put holes in the walls when they were starting to move furniture out, right? Because buyer shall immediately report to seller any objections to these conditions and buyer's requested corrective action. You do not close until it's fixed. Because when you close, you are saying that all conditions have been met and are acceptable. Okay. This is where we're looking at our sheet on the MLS to see like what we're getting for possession. So for this one, they had said right here that possession was close of escrow. So this one is possession at close. Okay. Or you would be saying, you know, if they want 30 days, then at blah, 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 on the day after completion of closing, seller has the privilege to occupy the property and agrees to pay the buyer X amount as an occupancy fee for this period. Now, most of the time, you know, that seller gets possession at no charge. But if we are going to charge them to live there after close, like a rent back,
right,
that's where this dollar amount goes in. Okay. And again, we would have a temporary occupancy addendum with it. Here's one thing that you should never, ever, ever leave blank. If seller fails to deliver possession to the buyer on the agreed date, seller shall become a tenant at sufferance and shall pay to buyer as liquidated damage X amount per day, plus all the buyer's actual reasonable attorney fees incurred in removing the seller from the property. I have all kinds of people too who, when they write a purchase agreement, they leave that blank or they put 0 in. That is protection for your buyer. I'm sorry, Carrie, say that again.
how do you know what to put? Like you just,
I put an astronomical amount of money in there. I put
say,
500
like,
bucks a day.
Okay, so seriously, $500? Okay.
It's like a squat, I mean, it'd be like, yeah.
Well, here's what this says.
So they
What
need
this
to get
says
out.
is, let's say that we are supposed to have possession at closing.
Sure, and now they're.
Okay, and we did our walkthrough 2 days before closing. And a lot of stuff is out, but there's still a lot of stuff there. Okay, well, they still own the house for 2 more days. And they go, oh, not to worry, you know, we've got the U-Haul and all the college kids' buddies coming tomorrow, and that's when we're gonna get everything moved out.
Okay.
All the college kids' buddies didn't show up, and they didn't get everything moved out. And you don't know, because they didn't tell you. Now you go to the closing table and everybody's closed and you own the property and you think you get to go over and move in with your keys, but guess what? They're still in there with all their stuff.
So they're getting $500 a day charged for
Yep.
every day that their stuff is still there.
Plus any attorney fees, any other expenses that you have to incur. So, again, like you're gonna have to go to small claims court to get it. But it's clear cut that you're gonna get it.
Right.
So now you have all your stuff going into a moving truck the following day, and you don't have possession of your house after tomorrow, so you gotta live in a hotel for 4 days until they get out. If you put a 0 in there, sure, you can go after them for damages, but then you have to go in and certify, like, what do I actually have as damages? Like liquidate it. And a judge is probably only gonna give you like what it costs you to stay in the hotel, what it costs you to rent the truck. Well, with this, you get all of those, plus your attorney, plus your time, plus the money that's in the contract. And that is a very big persuader for people being out on time. When there's no penalty,
Who cares?
who cares?
Okay.
Okay. All right, then we have that earnest deposit. What is our earnest deposit?
1% of purchase price. Are you asking for a dollar amount? Or
I would say, like, what is it? Why do we have an
Just a
earnest
good
deposit?
shows how serious you are.
Shows how serious you are. It is a good faith deposit, and every legal contract has to have a monetary value in it to be a valid contract. Your earnest deposit could be $1, and that would make it a valid contract. Generally, we tend to see 1% of purchase price. So if it's a $300,000 house, you would generally see about $3,000 for that earnest deposit.
Have you ever seen a dollar?
Yeah, but usually it's something like when both parties know each other
Right.
or something. In general transactions, no. And I will be honest, I know that it doesn't have to be a set amount. But let's say that I had a $400,000 house, and I'm the listing agent, and the buyer sends me the contract, and they're only putting $1,000 down for the earnest money. Well, I know, like, if they've got all those different outs, right? And if they walk back, they're getting it back. But I'm gonna call and go, why? Because to me, that says, we're not super motivated to buy your house. We're just putting our toe in the water here. Right? I mean, why would you only give me $1,000 for the earnest deposit? Or it makes me think that something is shaky with their financial situation and they're not gonna have the money they need to close. So I'm not going to accept $1,000 as an earnest deposit on a $400,000 house. Again, it's not my decision, it's the seller's decision, but I'm going to counsel the sellers on why I would make that decision, and that's what we're gonna do.
People get burned.
People do get burned.
Yeah, my friends did. Their listing agent didn't make them, or didn't advise them to, like not accept or get into a purchase agreement. There was no earnest money on it. The people backed out. And
Well,
then they were out of
But if
this deal.
if they backed out within the legal reasonable parameters, they would not have gotten to keep the earnest deposit
No,
anyway.
it was like after, it was a shady
Yep.
situation, yeah.
Lots of agents doesn't mean they're any good. So this is where we're gonna write in how much your earnest deposit is, and then it shall be submitted to, this is our broker holds earnest deposits. Like some brokerages don't, right? They have like the separate, the title company holds it or they have a holding company.
Right.
But for us, that's Keller Williams Grand Rapids North who's going to hold it.
It's never made out to you as the realtor,
No,
ever, okay.
ever. And it has to be collected within 72 hours of the effective date of this agreement. We use the app. It's called Earnest. Do you guys all have it? No, I see some no's, some yeses. Okay, we need to make sure that you get Earnest. And with that, you just go in, you fill out like their name, their email, right? You have to put in the property address and that kind of thing, and then you do the request and it sends it to them and they pay it and it transfers into that account.
How nice.
They can still do a check, right? Like they can bring a check right here to the office, but it's always made out to the brokerage. It is not made out to you. You do not hold it. It has to be in within 72 hours. This is something that Ed can get in big trouble for and get big fines for. So you have to make sure you're doing that earnest deposit. Okay. Okay. Now let's go into other provisions. So this is the last really important part that we want to hit on this purchase agreement. Along with that page, you also have the broker-to-broker compensation agreement. Okay, here we go. It's called the West Michigan Regional Compensation Agreement between brokers. Okay. And this is what Peyton and Katie were asking me to clarify before I left. This is the other thing that everybody got confused with Ed. There are two different ways that you can get paid or ask for payment. At Keller Williams, we prefer broker-to-broker compensation. Okay? So what that means is the listing agent had said, I'm going to charge 6% for doing this transaction, and I'm going to hand 3% to the buyer's agent who brings the buyer. Right? That's outlined in their contract. So then I call Susan and I say, Susan, are you offering broker-to-broker compensation? And Susan says,
Yes. 3%, right?
yes, we're offering 3%. Great, thank you very much. Then on line item 27, I'm going to say, see broker compensation agreement. And I'm going to have this filled out. And it's going to say like 3%, right, of the purchase price of the property on it. And it's going to be submitted prior to or with the purchase agreement.
Okay, submit with.
Mm-hmm. So if you notice, it says in the B section of here, the fully signed agreement is delivered prior to or with the buyer's offer to purchase. If you get an agreement with them and your guy is gonna buy the house and you forget to send this over and then 4 days later you go, oh, I forgot to send the buyer broker, I'll send that over. They're not legally obligated to pay you now. The form says, right? Delivered prior to or with the buyer's offer to purchase. That's why I've said you have to understand these forms or you will not get paid. And here's the thing, I'm a really nice person. I haven't said no yet, but I might.
'Cause then, yeah.
I could refuse to pay them.
So this has happened, people forgot this with you?
Oh, yeah.
All the time. Okay, so if we have called or texted and they have said, yes, we are offering cooperating compensation or broker to broker, this is what you fill out, that's what you send in. Now, if they have said, we are not offering broker to broker compensation, then we're not filling out that form. Does that mean that we're not going to get paid? No, we have other ways to ask for that.
No.
No, we're finishing
I was
this
gonna
up
say,
and then we're
that's
gonna
still
eat.
really heavy, why is there so much?
Sorry, because I'm still yapping. Okay, so when we ask that question, that is where we're going over here to this line 27, which is other provisions, okay? And that is where we're going to request that they compensate us. Okay, so I think because this one doesn't have the edit text line, it won't pop it up. It's not, okay, hold on. There we go. Okay, so seller to pay. That's our buyer's closing costs, prepaids, or other brokerage related expenses. You can also ask, you know, like seller to pay 3%. Why is this doing this? Sorry, it's being all goofy right now. Okay, to pay 3% purchase price for buyer agent compensation fees, right? So this is where you're gonna do this ask. Now the reason these are completely separate in two different things is because when your listing agent has asked them to compensate the buyer, right, with broker to broker, it's spelled out in the listing agreement that you're going to pay that 3% to them. So that is an agreement between you, your broker, and the buyer's broker. It's a broker to broker agreement. When the seller has said, I don't think I want to pay the buyer's agent, but I probably would if they ask. Why don't we just wait and see if they ask me for it? Now, that is an agreement between the buyer and the seller, not the broker and the broker. Does that make sense? Okay, and that's where that gets confused all the time. You do not do both. If they are offering buyer agent compensation, you do not fill out this form and ask them to pay you here. Then they're paying you twice.
So it's one or the other.
One or the other. Okay, that is the second most important takeaway of today, besides agency relationship, is that you understand that. So broker to broker is an agreement between broker and broker. Writing it in on 27 is an agreement between the buyer and the seller. Okay, good?
Yes.
More questions on that? Go ahead, Aubrey.
Which scenario do you see more? The brokers working it out or the buyer and sellers working it out?
We see both right now. Keller Williams, Greenridge, I think 5 Star, we all do broker to broker. There are other ones out there, and please don't anybody hold me accountable for this. But I think like 616, City Shore, some of those are not doing broker to broker. And it doesn't mean that one is right and one is wrong. It just means they're not doing it that way. What's important is that you understand how to put the ask in if they're not doing it that way. Okay, then this also says, right, that you can collect fax and electronic signatures. It talks about wire fraud. And then you go through and you sign and have them date, and then you submit that to the listing agent along with their proof of funds, right? Always include that proof of funds when you submit an offer. And I'm gonna give you one more little tip here. Let me go into one that's filled out. So when you're in .loop and you are submitting something to the other agent and you hit share like this, down here at the bottom it's going to say attach a PDF to the email. Always attach a PDF to the email. Okay, that's another one of my pet peeves. And if you ever are in the situation where you have a house that has 6 different offers on it, .loop will actually import the loop from what they created like into your account, and you have to go erase it, and then it'll stack them. So it's ridiculous trying to keep straight whose is whose is whose is whose. you need the PDFs. Okay, any other questions on purchase agreements? That took way longer than I thought. We are gonna have to boogie. So, I would say let's take like 15 minutes, do potties, whatever, and then are you guys okay with just having a work?
Yeah, that is.
I don't know either.
Alright, ladies and gents, let's get back to rolling again here.
Alright, man.
So
Catch
we
up
don't
on
run out of
Friday,
time.
figure out some more things to go ahead and do, and we'll make it.
Yeah,
work
and
stuff.
if you have other
So long as it's getting along
questions
your
that we
plate.
haven't answered yet, just make sure you write those down and we will go back to those, okay?
So, you'll get there. Let me know if you guys need anything. All right. Full table, hot tub.
Yeah, we'll see more to this.
Well, do you enjoy your house? That's pretty good. Yes.
Okay, so we're gonna start with the listing agreement on this one. We have everybody back in? Okay, so, remember we talked before on the buyer's agency about not just auto-filling, right? But we were copy-pasting, like our descriptions and all that kind of stuff. And on the listing agreement, right, you are responsible for representing the information. And you need to represent the information as true and as accurate as you possibly can. It's okay. And just because a house was listed before, does not mean that that listing agent had the information correct. So we do not deem that to be reliable, in my opinion. So, if everybody does not have this written down somewhere already, I want you to write this down. It's BS, the like ampersand A, and I'm gonna do Kent County for now. Okay, so I'm gonna write this right here on the board too. So it's BS, and then that ampersand, like and A, and we're just today gonna go to Kent County.
Is this for any county?
No.
Okay.
But you can go to BS and A. I'll show you. So let's say that I wanna look at like Montcalm County, okay? So I can go BSNA Montcalm County. And then when I open that up, then it's gonna let me search for any in Montcalm County. I can go up here and I can change the municipality. So let's say I'm gonna go to Kent County, right? I type Kent County in and it takes me back to Kent County. Okay. So, what we're gonna do here is, does anybody have a property address that you wanna share with me? Anybody want us to use their personal, is that okay?
I'm sorry, what are you pulling up?
A house.
Yeah.
Mine doesn't show up yet.
You can,
Okay, let's try yours.
600 Broadway Avenue.
Okay, so I'm gonna type in 600 Broadway Ave. I'm going to leave it generic. But apparently, you have a condo? Okay, that's why, that's gonna give us a gazillion addresses.
Is that too
But,
much?
You want mine? You want mine?
sure,
Okay, 7820 Wedgemont.
Wedgemont.
DGEMONT Court.
Okay, I'm just gonna put in Wedgemont, I'm gonna leave it generic. And we're gonna see what we get. So if I click on this parcel number, then it's going to tell me, you're in Caledonia, right? This was in the Charter Township of Caledonia, so I click here. Okay, and that's gonna take me to the property address.
Yeah, that's it.
Okay, so
Mostly.
so here's the thing though. We used BSNA exclusively for many, many years. It was considered the best resource that we had. They have changed the way they do things, and it is not always the authority right now when it comes to the owners of the property. So I actually had one a couple of months ago where the deed was in both parties' name, husband and wife, and it was a ladybird deed and he had passed away. Right, so with the ladybird deed, that gives her all the authority to handle the property with the death certificate. But when I checked it on BS&A, it only had him listed on the property. So I had to pull prelim title to clarify and make sure we had what we needed. We can also find this information in this realist tax info. Okay? But BS&A is still your best choice to go to for your first round of investigating. So when I'm looking, this is going to give me the property owner. So the first thing that I'm looking at is to see who the property owner is. And if they are listed as a property owner, then that means they are on the deed. If they are on the deed, they must sign your documents. Okay? Now before, when we talked about that married versus single, you can have marital property where only one person is on the deed. But if they're married, they both have to sign the documents because it's considered marital property.
Sure, for sure.
Does that make sense? Yes, Aubrey.
What does the B mean in the BS&A?
I have no idea. I just said BS&A. This is what we use. So I don't know what the actual name of the service is.
It's an odd name.
Yeah. Okay. Now if I'm looking here, it's going to give me the year that the house was built. Kent County is usually going to be pretty accurate. The outlying counties, yeah, go ahead. It's hit and miss on what you're going to get. So Dusty, this says that you have 3 bedrooms, 2 full baths, and 1 half bath. Is that correct?
No, we have 4 bedrooms and 1 half bath and 3 other bathrooms.
Okay, so it's not, that
It's
part's
not
not been
correct,
updated,
no.
not correct. Okay, are we on 0.504 acres?
Could possibly be.
Okay. The biggest thing that we're looking at here is like who is on that title, and then this is also going to give me, again, like the acreage, it's going to tell me what it's zoned for, right? R1, which means residential. We wanna make sure, because if something is zoned commercial or mixed use or any of that, it can change all the factors. Here is my legal description. Okay, and then here's like my square footage and stuff again. This tells me that it's forced heat and cool, so I know it's got a furnace and AC. This, a lot of times this one's not filled out here, but frequently it'll tell me if it's on public utilities or if it's well and septic. Basement finish, right? And then it tells me here that we have a deck, right? If we have outbuildings, it will usually tell me that too, right? So if we have a pole barn, it's usually gonna have the dimensions, how much square footage or whatever I have in a pole barn. The other thing about this is, if I go here, it's gonna give me tax information. So this is gonna show me what my winter and summer taxes are, because you're gonna have to have that information. And then if I go to building department, then if there have been, you know, like,
Taxes.
it's probably not updated yet.
No.
But here it's gonna tell me too, like something was done with the electrical, right, in 2012, something was done with the mechanical in 2012, and the plumbing in 2012. So it may not tell me what it was exactly, but I know in this case that a permit was pulled for it.
They put in a new drain field, like right before we moved in, that could be what it was.
So this says furnace replacement if I open it. That was the mechanical, right? So that will help me discover, right, whether or not something was done legally or not. Does that make sense?
If you know this house has just been updated and they pull, you look at these and there's no permit pulled, what are you doing then?
Well, one, it either means that the permit was not pulled.
Right.
Or 2, it's just not been updated in the system yet.
Let's say they didn't pull
So,
permits.
hold on, Dusty, give me that address again.
Oh, 7820 Wedgewood. Mont. Nope, Mont. I mean, you'll probably get one in our neighborhood with that, but.
Okay,
Maybe.
so if a permit wasn't pulled, I mean, that doesn't necessarily mean that you can't sell the house.
Yeah.
People do stuff all the time without pulling permits.
Right.
Right? But the same thing, and it's different with every township, municipality, whatever. But if you pulled a permit to install a new furnace, and you used one of the legit companies, like Vogue or one of those, they will pull the permit. You're actually paying for it. It'll be on your invoice, right, that they pulled the permit. And then they submit that paperwork to the township, and then the township supervisor or that department will call you and schedule an appointment to come out. And they're going to check it and make sure that it was installed properly, and then they're gonna put a sticker on it that says it was approved by the township on this date. So anytime you're doing that look-through in the home, if it has those stickers on it, right, then you know the permit was pulled. Okay, but now let's get into this. I'm going to have this open most of the time when I'm filling out my listing agreement. And the reason I'm doing that is because at the top, I have to fill in those street addresses, the tax ID number, the parcel plat number, all that stuff. And it's easier for me to just copy paste. Okay, so let's start at the top. So, the seller is granting Keller Williams Grand Rapids North, who is the broker, from today's date to whatever the date end of the contract is to sell the home. And again, it's you and the seller who decide on what that date is going to be. I usually write mine for 6 months. If I can't sell your house in 6 months, then I shouldn't have been trying to sell your house anyway. I'm not doing my job. Okay. Let me take that back. Unless the house is like 2 million. Because on average, those usually take about a year to sell. Rephrase that. Okay. And then we're check marking if it's in the city, the township, or the village, which is going to be on that report. So for this one, we would say like Caledonia, County of Kent, and then here's the street address. So you're putting in the street address, the city, right, Caledonia, Michigan, and the zip code. With the following legal or tax description. So if I go over here to my BS&A report and I scroll down, right here is my legal description. Lot 18 asterisk Listening Valley. This has to be copied exactly the way the listing or the legal description is on these forms. Okay, because this is how it's going to be on the deed. So it has to be exact. Now the next thing that it's going to ask me for there, once I fill in that legal description, is the approximate lot size or acreage. That we're going to pull from up here at the top, where it says my acres are 0.504. Then it's going to ask me for the parcel plat number, or the PP number. That's right here, parcel number. So I'm going to copy paste that over. Now if it's a condo, then it's going to say in that legal description, actually why don't we do that one again? Give me that address again, please, Carrie.
600 Broadway Avenue, Northwest.
Okay, so it doesn't matter if it pulls up 50 of them, I'm just gonna pick one. Broadway Ave. Oh, you know why? Because I'm in Caledonia. Let's go back to my municipality again and pick my K's. And I gotta go down to Kent. Is it City of GR?
Yep.
Okay, City of Grand Rapids. Okay, we're going to 600 Broadway. Okay, so if I go down to my legal description, see how big this is? Okay, but it's gonna say unit number, right here, this is unit 2. In the blank condominiums, so this is gonna be Union Square, Kent County Condominium Subdivision. And then it's gonna say, according to the master deed recorded in Lieber and Page. So somewhere down through here, if we're reading through here, by plat number 7, by instrument,
Oh my God, what a nightmare.
this one is
where we
actually,
text you.
what's that?
I said, this is where we text you for
Uh-huh.
help.
Yeah, and this might actually be cut off. See where that's good? It's not completely ended there.
Yeah.
So you may have to call the township to get the full because after it goes through all of this, then it will say like in Lieber blah, and it will have a page number or a document number that it's filed on.
He's in there.
Okay? So that's where we find that out. If you have a condo or an HOA, you must have the information from the seller. Those documents have to be uploaded with the listing.
I found a listing the other day that has a small engine repair manual in the document.
Did you notify the agent that they had uploaded the wrong document?
The whole listing is very confusing and I wasn't sure what to do with
What do you
it.
Okay,
What are you uploading for condos?
Report.
The HOA?
the HOA docs. And then when you list it in the MLS, it's going to ask you like who is the contact for the HOA, and then you also have to provide like a phone number or an email for the HOA. And sometimes people don't have those. So again, let's say I'm meeting with my seller next week and I know they're in an HOA. I'm gonna say, do you have a copy of your HOA docs? Nope, I have no idea. Is it managed within your neighborhood or is it managed by a property management company? Okay, great. Like I need the information on all that, and if possible, we need to reach out to them right away and get a copy of those documents before I arrive. Because you need to know it. One, it has to be uploaded, but two, you need to understand, are there fees, right? Are they payable monthly? Are they quarterly? Are they yearly? What's included with those fees? All that information has to go on the MLS. Okay. Now let's go down here. Agency representation. All right, so for this, the seller is acknowledging that they are reading and signing the agency disclosure statement, which we did earlier today, right? So you understand that you're not going to disclose confidential information to any licensee that the seller would not disclose to a buyer. And that we are appointing your name. So this is where your name goes in. Seller appoints you as the designated agent for this agreement, and that our broker is Ed Hansen. Okay, possibility of dual agency. If the broker acts as a dual agent, seller consents to this dual agency and agrees that under such circumstances, the following provisions will govern their actions. The broker will not knowingly say anything or do anything which might place one party at a disadvantage. The broker shall assume a role as an intermediary, facilitator, and/or mediator to assist buyer and seller. And the broker shall not disclose to the buyer that the seller might accept a price other than the purchase price that's listed on the MLS. Okay, and everybody did understand what makes dual agency, right? Okay, Land Division Act. We're basically saying that if the property is not platted and the seller intends to divide the property for sale, then the seller must comply with all terms and conditions of the Michigan Land Division Act. It's very, very rare that anything is ever going to happen with that paragraph. So if we need to, we can talk about that when the situation arises. Then we get into those fixtures and improvements, which remember we also saw on the purchase agreement. So if it is screwed in, it stays. That's the best way to remember that. So let me ask you a question. You have a builder that builds a house and they use those standard mirrors in the bathroom, right? That are like the flat, full wall mirror that are attached to the wall. It's screwed in, it stays to the wall. Your seller has updated all their bathrooms and they have these gorgeous mirrors that came from Home Goods but they're basically hanging on a screw, right? Is that permanently attached to the wall? No, it is not. So, that is something that we need to remember when we're looking at this. And I thought maybe they did not add that back in now. Yeah, see, it just says all attached mirrors. Still, that's not an attached mirror. So whether you're representing the buyer or you're representing the seller, you need to be very clear on those bathroom mirrors if they're mirrors that are hanging on the wall on screws. I always tell my sellers at the very beginning, buyers are going to expect the bathroom mirrors whether they're attached to the wall or not. So just plan on it. You're leaving the bathroom mirrors. But legally, if your buyer did not ask for them in the purchase agreement, it's not covered under this paragraph. Good? Good. Okay. And it's also asking us a few questions, like the attached smart home devices and attached security systems. Are they owned or rented or not available? The reason we're asking here is because sometimes if you have like ADT, that is your security provider, like they give you all the stuff that goes with the house, but you have a 3-year agreement with them, right? A 3-year contract that you're going to use their services. So you don't technically own it right then, it's rented. And what will happen is the buyer either has to agree to assume the contract on that security system, or your seller is going to have to pay off ADT for the full amount of that contract before you close. Same thing with solar panels. Don't get solar panels in Michigan.
No.
See you live this Saturday.
What is that? Sorry, my phone is going off and somehow Mariah Carey jumped on. I can't stand Mariah Carey. Okay. And it's also going to ask here about water softeners. Because if you have a well, a lot of people have water softeners. Some of those systems are owned, some are rented. If it's owned, it's staying with the house. If it's rented, then they have to work out an agreement with the company. Water heater, I don't know why this is on here to this day. I've never seen anybody that had a rental hot water heater, but I suppose it happens. The other ones that we have here are liquid heating and cooking fuel tanks. So again, that's your propane tanks. And also like satellite dish, necessary accessories, and complete rotor equipment. We still run into that one a lot. If somebody had Dish Network at one point in time, and it was 10 years ago, and they don't have it anymore, but the dish is still on the roof, technically Dish Network owns that equipment. They're never going to come back and get it, but they own it. So in that case, we would be checkmarking rented, just in case Dish Network ever decided to come back and get their equipment. Okay? Then this is where you're going to write in very specifically what's included with the property. The refrigerator, the dishwasher, the play set that's in the backyard. And if we're keeping Aunt Shirley's rose bush, then it goes in here, but it does not include Aunt Shirley's rose bush.
And the seller has a lot of aunties with rose bushes.
You would not believe some of the fights that we've had over landscaping over the years. All right, heating and cooking fuels. This specifically states that we have to leave the tank at 10% or more. So again, I'm having that conversation with my seller, especially if we're like going into winter, right? If it's like June and the tank's at 35%, we're probably not gonna have to do anything to it before we're closing. If it's October and we're going on the market and the tank's at 25%, they're probably gonna have to have part of it filled up. But I always tell them, like, don't do a full fill, right? How much will your company do? A lot of them won't do less than half because it's not worth their time to do it. I say then do a half fill. We only have to leave 10% of the tanks, and I don't want you to pay for a full tank. Sometimes you'll get those nice, 80-year-old grandpas who go, I filled the tank up for them because it's just the right thing to do. That's on them, not me. All right, sale price. This is the price that we are agreeing to put it on the MLS at. Any questions on that? Okay, terms. What terms are we going to accept in an offer? Cash, a new mortgage. For new mortgage, we're selecting conventional, VA, FHA, MISTA. We also have the check mark here for other, which could be like RD or rural development. Okay, here's another thing that you need to make sure and you are aware of, especially with condos. There is a process and a procedure that they have to follow and paperwork that they have to file with the government to become eligible for FHA or VA financing. And they have to renew that paperwork every 7 years. You will find things where listing agents have checkmarked that it's available for VA and FHA. And an FHA buyer writes an offer and they accept it. And then they find out they didn't keep up with filing their paperwork and they're not eligible for FHA financing. This happened to my good friend DJ, right, like 2 months ago. So you as the buyer agent should be checking to make sure that this property qualifies for that type of loan. And you as the listing agent should be confirming that it is available for that type of loan before you list that you'll accept those offers. And there are government websites for it. You can also call Treadstone and say, I'm putting 600 Wedgwood, 600 whatever, Broadway on the market. I need to know if they are still qualified for VHA and FA finance, or FHA and VA financing. And they can look it up and tell you.
Can you go back in and get qualified if those people want to use?
I have a Treadstone packet to hand out to you too before we leave. Can they go back and get it? They can. Yes. And in DJ's case, that is what they did. But it extended the closing by 3 weeks for them to go in and get that back in order. Okay. Why? Why are those different?
Different qualifications for those particular loans, like VA has extras for pest inspections and.
Which has actually been removed now.
Oh, has it?
Yeah.
But also, like you were saying earlier, everything has to be fixed and proper before closing.
Correct. So usually what the FHA and the VA are looking at when it comes to condo world is making sure that like their finances and their reserves are in order, so that, you know, like let's say that the building needs a new roof and they have no money set aside to pay for a roof, right? That's what they're looking at. How healthy is the fund to make sure that my buyer is making a safe investment? Did you have a question, Leah? Okay, sorry, I thought I saw your hand kind of do this, and I'm like, did she need me or not? The other thing is, right, VA, FHA, MISTA, and RD can all have those requirements for health and safety issues. So again, like missing handrails, peeling paint is one of the #1 things they're gonna call out for any property. It doesn't matter if the property was built in 1988 and does not have lead-based paint. If it has peeling paint, it has to be corrected. And it does not just apply to the house, it also applies to all the outbuildings. You could have a chicken coop that's falling apart, that's half a mile away from the house. And it would have to be fixed or removed as a condition of VA, FHA, MISTA, or not RD, MISTA financing. So this is a conversation that you're having, give me just a minute, Aubrey. This is a conversation that you're having with your seller as well about what types of loans you are going to accept for this property. Right? If I have a house that's in a neighborhood that's 20 years old, right? I'm not worried about VA or FHA. They might find a couple little things that we're gonna have to fix, but all in all, I don't have a crumbling out building, right? I don't have those kind of issues. Of course I'm going to accept those kind of loans because that gives me more buyers to pull from. If I have sellers that are in their 80s and going to move into retirement home, they don't have anybody to help them. They've really let the property go downhill in the last 10 years because they haven't had any help. And I know there are a gazillion issues that are gonna be pulled out by the appraiser on these, then I'm going to recommend that we only go with cash or conventional. because it would just be too much stuff for them to have to fix or take care of as a condition of the sale. Does that make sense? Okay, Aubrey.
Did you say condos deal more with the VA and FHA? Like, were you saying something specific about the condo listing?
No, but I'm saying that, like, with if you own a house, right, then you don't have to have anything approved through the government to be eligible for a VA or an FHA loan. Condo developments do.
That's every 7 years.
That's what it is.
Condo developments need that pre-approval.
And again, usually what they're looking at is they want to make sure that their finances and their reserves are in order. When the VA's job in issuing loans is not only to give good interest rates and that kind of thing, but to protect that veteran. They had all the good intentions when they created it. A lot of it needs to be scrapped and redone. But what they're saying is your buyer just bought this condo and the fees are $100 a month. And then next year there's a huge hole in the roof and you find out that the condo development did not manage their money effectively and they don't have any money set aside to pay for that roof. And it's gonna cost $80,000 to put a new roof on this building. And when they do that assessment, that now comes down to $8,000 per tenant that they have to pay. And your VA guy doesn't have $8,000 to pay for a roof. So $100 a month, $8,000. That's why those kind of things are in place, because they're making sure that they're financially stable for the person who's buying it. And that they don't have a bunch of health and safety risk, right? If you have a big development like yours, right?
Elevators,
Yes,
stairs.
elevators, stairs,
Yeah.
fire, flame retardant, right? Between the units, that kind of thing. That's what they're looking for. Okay, I'm gonna skip on. Seller financing, I'm also not gonna cover here. I have heard a few people in the meetings ask about selling on land contract. Land contract is a fabulous option for your sellers. You cannot sell land contract if you have a mortgage or owe money on a property. You have to own it free and clear. And that is more rare. So we'll address that situation if you ever need it. Okay? All right, now this is where we get to this fun part with what we were talking about with the other one. Broker to broker compensation. So, this is what you need to make sure that you understand completely in filling out. The seller agrees to pay the broker a fee of, dollar amount plus percentage of the sale price, or flat fee, whichever is greater, due and payable. So, you do have a transaction fee. Everybody does. So that is your dollar amount. Like mine is $4.95. So my transaction fee is $4.95 plus 6% or 7%, 8%, whatever you're agreeing to with the seller. The total percentages. If I was doing vacant land at $25,000 or something, then again, that's where I would be putting in that flat fee for selling it. Okay. And then I'm also going to put a year here in this, or the property is sold or leased within 12 months. That again is protecting you on this side from somebody reaching out to your seller and saying, hey, I'll buy it, just cancel your contract so you don't have to pay the realtor and we'll settle at this fee. Okay, if they were exposed to it from you marketing it and that brings in the buyer, they are obligated, they owe you the commission. Okay, but here's where we're taking this and we're cutting it in half. So what we're saying is, yes, Mr. Seller, you're going to pay me 6% total, and I am going to offer 3% to the buyer's agent who brings the buyer on your property. So your sub-agent of the seller, you've got 0, 0, 0, 0, 0. You're writing in 3% on that buyer agent box, and that is it. Everything else is zeroed out. So that is how we offer to other agents. Now let's say that your seller said, I'll agree to pay you 3, but I'm only going to offer 2.5 to the buyer's agent. What do I write in those lines?
2%.
2.5.
Or 2.5. And buyer's agent down there. And then
Uh-huh. And then
5.5.
5.5. Yep, up here.
Let's say we're like, well, we're doing it for 6, and sorry, like,
What do you
we're,
mean?
as the listing agent, you can't set. You can't say I'm not doing it. You can say I'm not gonna do it for
You have a
5.5.
right to
Yeah.
charge whatever you want for your
Right.
services. They
Right.
have a right to accept or reject what you want to charge for your services.
So if they say 5.5, you can say, all right, I agree to that, but you don't have to.
You can.
Yeah.
However, it is our policy here
I mean,
that if you were to not do the 6 and 3, you have to have permission from your broker in order to do that.
okay, anything different, okay.
Until you have achieved a level of sales where they say do whatever the heck you wanna do.
I got you.
But
don't some like newer agents say to drum up business, like,
newer agents, all kinds of agents. They
Oh,
will
okay.
try, I actually reported somebody the other day because they've got, list with me for 1% on their sign that's
Oh,
out in
yeah,
front of the
that's-
property. It's illegal. You can't do that anymore. There is an agent who shall not be named that operates out of Caledonia who works for the Caledonia school system.
It's not me.
And he's been an agent.
Sure.
He's been an agent for 15 years. And his motto is, buy with me and sell for free.
what?
That's his motto.
Okay, so,
So that's what his motto has been. He's also like the worst agent in the universe. There is no communication with him and he's horrible. But what he's saying is, you buy with me, right? And he's getting cooperating broker, so the broker's paying him. They're not paying him
when
any
it
money to
comes
buy.
time-
And then he offers to sell it without taking any commission on it. But what you will frequently find is that he pays 0 attention to what is going on in the area. He lists it for whatever the seller wants to get out of it. And what happens is they spend 6 months on the market and it never sells. And then somebody else comes in and actually sells it. And then
Sad.
they get the full 6%, right? Oh, I had buyers, again, this was probably 9 or 10 years ago, David and Tiffany, and we were selling their condo in Fox Chase, and they wanted the kids in Forest Hills. But they had a pretty low budget to be in Forest Hills, and they wanted to be in the Ada area, right? So I don't know if you guys are familiar with like Ada Craft, Ada Commons,
It's most
right
expensive.
down that way. No, it's actually pretty cheap to be in Ada.
Oh.
But at that point in time too, it was still way cheaper because it was before the village was getting fully developed, right? We were in the process of developing.
Okay.
And a house popped on the market that he was selling because the buyers had already moved out. He had helped them find the other house, but he didn't do his homework. That house was priced $50,000 less than what it should have been. So the second I saw that hit the market, I called David and Tiffany and I said, this house is way underpriced. It's got a couple quirks, but it'll work, you know, and it will get you in at your price point. We need to go like yesterday. We were at that property within an hour, and within an hour of leaving, I had an accepted offer. And the appraisal came in $60,000 over our purchase price.
Yay, you. That's awesome.
How is he still working and so bad at it?
Because
They
people,
don't-
stupid people get suckered in.
And they just they don't learn from it?
You don't think his reputation would precede him?
He doesn't get repeat clients.
Yeah, or trained.
So anyway, yes, you can agree to whatever price you and the seller agree to. You will also have ones that want discounts, right? And maybe they agree to 5% and you do 3 and you offer 2 to the buyer's agent. But you can't make that decision. You and the seller have to make an informed decision together.
What if the buyer's agent doesn't want to? What if they want 3? They don't have a say. They have to be okay with whatever's written on it. If their buyer wants
Again,
the house.
that is technically between the buyer and the seller. So
Yeah.
let's say that you said, yes, Dusty, we are offering 2% to a cooperating broker. They can send you the form asking for you to pay them 3%, and you can counter back, right? But you don't get to make that decision. It's your seller's decision. But that's where you go to them and you say, you only agreed to offer 2. They are asking for 3. Are you willing to pay the difference? Not like their buyer has to make up the difference, right? I'm not gonna cut mine
Right.
to give it to them.
Okay, so then their
It's on
buyer
them.
could potentially give them the other 1% if they buy the house.
They could, but it's up to them. All right.
Doesn't Keller Williams have a minimum, like, requirement to list a house?
No, ma'am, we are not allowed to have a minimum requirement. Again, that is against, that's against the NAR lawsuit. We're not allowed to say there is a standard. This is the normal. This is what most people do. Every conversation there is between you and the seller. However, as a new agent, Keller Williams will not allow you to list a property for less than 6% unless you've had a conversation with your broker.
Okay, that's what I was,
Yes.
that's what was in my head, is I thought there was like a minimum.
There is, and the reason though that we're having that conversation is because again, I mean, you could get new agents who have no idea what they're doing that come in and offer to do everything for 1%, but they still don't even know what they're doing, right? You need to understand how to do it and how to do it well. And again, like, why would you shortchange your worth? Right? If you can't communicate your value enough to your buyer or your seller to get the contract signed, then you're never going to be a successful agent. You have to learn how to communicate your value. Okay, but now, here's the other thing. Let's say that we're not offering compensation to the other broker. Then at that point in time, what's going to be up here at the top is what we're getting paid, right here. So that would be 3%. So when Ed was talking in the sales meeting about the agent that screwed up and gave away all their commission, that's because they wrote 3% right here on the sale price, on this, you know, like they're paying us, and then they offered 3% down here to the buyer's agent. So basically they said, yes, we're going to collect 3 and then we're going to give 3 of it away, and that leaves me with nothing. Okay, is that clearer? Now, okay, there is another way that you can offer this though. And some groups out there are doing this. You may also offer seller concessions. Seller concessions may be advertised on the MLS. So what we're seeing right now is that some companies, rather than offering broker to broker, are offering seller concessions. So when they check mark that box, and they say, seller authorizes broker to advertise and publish on the MLS like 3% of the sale price as a concession, then that is almost in essence saying, we're gonna pay you 3%. But here's the thing, a seller concession is paid to the buyer and may be used by the buyer for anything that they wanna use it for. Okay? You have an agreement with the buyer that they're going to pay you 3%, right, for your help in this transaction. But they don't have to apply if they get it in seller concession towards your 3%. They can use it for whatever they want. Prepaids, closing costs, anything that is related to that transaction. And here's the thing, when title is doing that work, if the buyer says, I don't want the fee for my agent included on my title documents, my TRID statements, right, which is like how much you're gonna owe at the end, they don't have to do it. They could say, I'm gonna pay my buyer's agent on my own with the check, and title can't stop it. And then what if they decide not to pay you on their own with a check? Now you gotta take them to court. That's why I don't like this.
And why is it there? That's a bad loophole.
It's a loophole.
Yeah.
It's exactly what it is. Everybody was going crazy when this first came out,
That's not good.
right? And trying to find loopholes and trying to find workarounds. And the biggest problem that we had when this first came out and agents didn't understand it is they were checkmarking both. So they were checkmarking 3% to the buyer's agent and 3% in concessions, which meant that they were offering to have their seller pay 6% to everybody on the buy side, plus 3% to the listing agent.
Okay.
This is not a and, it is an either or.
So just cross that off.
Do you
But
even talk
people
about-
were using it because legally you can publish that on the MLS. I'm just saying it's riskier. So I prefer not to see it that way.
Do you even talk about that when you're meeting with your people and going over this form? Do you talk about number 11 with them and tell them what it is, or do you just kind of breeze past it?
Well, if they ask, like, well, can you publish it anywhere? And I'm like, no, we can't legally talk about it, right? So what happens is every single agent calls me when they schedule the showing and say, are you offering broker-to-broker compensation? And we just have that conversation.
Yeah.
There are times, though, when you can do a and here's why. Let's say that we are going to do 6% and we're offering 3% in broker-to-broker compensation, but the carpet is horrendous and we know it has to be replaced, but we don't know what the potential buyer is going to like. So we would rather just provide an allowance to the buyer to get new flooring. Then I can check mark that we're offering 3% to the broker, and then I can check mark that the seller authorizes me to advertise, and in here, let's say it's 5,000, I can put 5,000 as a concession. So then on the MLS, I can say, seller is offering a $5,000 concession to replace the carpet. Does that mean the buyer has to use it to replace the carpet? No. But they're offering them a $5,000 credit because it's like acknowledging and saying, we know that the floors have to be redone, but we're gonna let you do it with what flooring you like. Okay? But otherwise, it's an either or, not an and. Okay, other questions on that? Okay, here's something else that I feel it's very important that frequently gets left out. Inquiries. Seller will refer to the broker all inquiries about the property received during the listing period. Everybody just skips over that one. I tell my sellers right up front, if anybody asks you about the house, just say, oh, that's great. Let me put you in contact with my agent, because they will use anything they can get from you against you, right? Don't tell them how much you're willing to take. Don't tell them what might be wrong with it. Don't tell them that you hope to have it sold in 2 weeks. Don't tell them anything. Just smile and refer them to me. All right, let's keep moving here. Title, right? We're gonna do that expanded coverage. So, and then possession and occupancy. So this is when you're filling out, right? Like, are they getting possession at close, or are we're asking for possession after closing? What is the max amount of days that we can ask for after closing?
60.
60. Why? You all know this answer. Speak up. Come on. I know one of you knows it. Why can you not get more than 60 days? Because to a bank or a mortgage company, if you are living there for more than 60 days after possession, you are now considered a tenant at large. So it is not considered a primary residence anymore. It's considered a rental property. And your mortgage was not designed for a rental property. Okay. The next part here, marketing. So this is gonna be like broker is, so you're gonna check mark is, and I check mark all of those on there just in case. The reason I do that is a lot of it's based on the area as well. So most of us in Kent County, we're fine with using the Century boxes. Probably Brandon's. But there are some places, even like, I was showing a house up in Greenville last week, and 2 of the houses that we looked at, I had no problem with the Century Box. The third one was kind of like more out in the country in Greenville, and it didn't want to connect. So a lot of what they tell you, because it's Bluetooth, right, with your Century Boxes, is that you should open the app while you have good cell service, and then it will connect when you get to the front door. Not always true, not always easy if you're driving, right, and something happens. So if I have a property where I don't have good cell service, I will put one of the old combo boxes on it, not a Century Box. Because you don't want people getting there and not being able to get into the house. Okay. This authorization to order services, again, this gives you permission to do that, but I don't order services on their behalf ever. The submission of offers, you're gonna check mark shall. If you're going to continue to submit offers until closing, and you're going to check shall not if you're not. So this kind of goes back into that backup offer that Brandy was talking about earlier. I always check mark the shall not on it. Okay, and this is one that's legally required to be in here. Some states allow people to still review offers all the way up until like 3 days before closing. Michigan does not. If we are under contract with a party, we are under contract with a party. We can't just a week before say to the buyers, too bad, so sad, we're cutting our agreement because somebody else offered me $10,000 more and I'm gonna take their offer. Okay, so I always have shall not on that. We are not allowed to discriminate. And then seller directs the broker that letters from the buyer will not be presented with any offer to purchase. Pay attention to that. You may not accept buyer letters. And again, there are a bunch of stupid agents out there who still don't understand that we prohibited that 2 years ago. On line 18, under non-discrimination, when you get down here to the bold, right here, seller directs the broker that letters from the buyer will not be presented with any offer to purchase. Why do we do that? Look at what topic it's under.
They tell you lots of things in those letters. We got so many of them when we sold our house in Minnesota.
Especially if there's photos
Yeah.
that come along with the letters.
Nope.
Discrimination.
The person getting the letter could discriminate against.
Yeah.
It leads to discrimination. And the reason it can lead to discrimination is because if you got 5 offers and you got 5 buyer letters and one of them is a family with 2 little kids, which is kind of like where you are, and then one is a single guy in his 30s and another is a gay couple, right, looking to downsize or whatever,
Yeah.
you could discriminate because you don't like the gay couple. You could discriminate and pick this one because it reminds you of your little family when you came into the home. So it's better that you're just going in and looking at numbers on a page. And there are buyers who get around this. So, Ariana, right? I sold Ariana last year. Joshua and Taylor. Cute little house. Ariana is a cute little street. It is a great, like, starter home kind of neighborhood. Okay. And we had 7 offers on this house. We were listed at 300. We had 7 offers. And I told them up front, I'm like, people are going to get sneaky and creative. And here's the thing, right? Because it's like, we're not looking at buyer letters. And I don't want to know anything about those people submitting offers. What I want to know is who's their pre-approval from, how much money have they got, and how much money are they willing to pay us. That's it. That's all we care about. So the offers start rolling in. I get the first phone call from Taylor around 2 o'clock. And she's like, flowers just showed up at the door. And I'm like, great, don't open the card. Go put them somewhere cute, don't open the card. Right? Then another gift showed up. I was meeting with them at 5:30. Right behind me came the pizza delivery guy. Somebody sent pizza. And all this other stuff too. So we're taking all those notes and just sticking them over on the side. I'm like, what we're going to do is we're going to pick your winner, and then we'll see who sent what. But that is not factoring in to us picking who's going to buy your house.
Do you think their realtor told them to do that on the down low?
Of course they did it. The realtor's probably the one that ordered everything. So I'm saying they get sneaky and there's ways around it. But if Taylor had opened that card and saw the name on it before we sat down to look at offers, she would have already had a preconception in her head, even though it might not have told me anything about them. She would still already be predisposed towards somebody that sent her the really great flowers that she liked, right? Okay. Modifications. This contract can be modified or amended only in writing and has to be agreed upon by the broker and the seller. That we fill out the seller's disclosure statement. That we warrant the age of the property, right, on our lead-based paint disclosures. This is all lead-based paint, so I'm not going into all that. Here. Sellers acknowledge and agree that the price, terms, and other details with respect to the property are not confidential. They're, disclosed on the multiple listing service. I will always check mark the, as the seller, I request that agent for owner appear on this field in the MLS. And there are a bunch of stupid agents out there that do that too, because in the MLS it says owner name. And you know what I put? Agent for owner. They don't need to know my seller's name, it's none of their business. If they're really adept and they know where to look, they can find it anywhere in public record. But it's not their business. And I always tell my sellers too, your name is still gonna show up everywhere when your house goes on the market. Because all those third-party websites also pull from public sources, not just the MLS. So, but I will not put your name out there anywhere on the web.
I have a question going back
Yeah.
to the flowers.
Okay.
Is that, if she were to open that and it doesn't share any personal info, is that considered discrimination?
No,
Yeah.
not really. It's just them trying to get a leg up on getting us to take their offer. And it's a workaround from the buyer letter. Because way back in the day, we used to say, write a letter, make them cry about how much you want this house.
Yeah.
Can't do that anymore.
When did that change? I sold a house.
2 to 3 years ago.
Oh, it was before that, yeah. We got
Yeah.
a bunch of letters.
It
yeah.
used to be where you could check mark whether or not they would or would not accept buyer letters. And for us, as Keller Williams, we always check marked no, because it could be an issue with fair
Right.
housing or discrimination. But the sellers used to be able to check mark whether or not they wanted them.
Oddly, that's why okay.
Okay, so indemnify basically means they hold us harmless, that they're consenting to the fees to sell the property. The broker remedies, if anything, comes up that has to be disputed with the property, it always goes to broker remediation first before it would ever turn into a lawsuit. Just like almost anything you see, even like condo docs or blah, 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 it'll say that you have to go to arbitration or mediation before you can file a lawsuit. That they're check marking that they are a citizen of the U.S. Do they have to be a citizen?
No.
No, they do not. I have clients right now that are here on work visas. They have TN visas. They can still legally buy property here. But the reason this has to be check marked is because when it goes to title, there are different tax issues that happen if you're not a legal citizen of the U.S. So again, not discriminating, it's based on taxes. All right, that we can collect fax and electronic signatures. We warn people about wire fraud and audio surveillance. This is a biggie.
This is weird.
And I always ask my people, do you have any cameras or listening devices in the property? It used to be there weren't that many that did. Now that we have Ring doorbells and all that kind of stuff, everybody and their brother has some kind of surveillance on their property. Your client may watch what is going on in their property, but they may not listen to anything going on in the property when buyers are coming to see it. Because buyers have the right to have a conversation with their clients about the condition, about what they might want to offer for it, right? All those things. And they have an expectation of privacy to be able to do that. So you can watch them standing there, but you cannot listen to them. Are they still gonna listen to them? You bet they are. So, when you are out with your buyers, I always tell them from the very beginning too, we are not having conversations while we are in the house. You know, and like I will have a clipboard too. You guys, you know I love my clipboards. And I'll say too, like if you have a question about something, just ask me for the clipboard. Write it down. We're going to talk about it when we get out of the property. But you are not going to ooh and ah and fawn over how much you love it. You're not going to talk about how disgusting somebody's bathroom is when we're in there. We're not going to talk about price, right? Like we're going to say, oh yeah, I like those built-ins, or this is really neat, but probably not my choice of paint colors. That's fine to say in a house. But if they can listen, they're probably going to listen. But you have to tell them that they can't listen. Do you know why that came about? What the first case was? No? Back in the days when we first started having the nursery monitors, right? People had the cameras and the little like walkie-talkie thing so you could hear the babies. And there was a couple that had their house on the market, and the lady was going next door to the neighbor's house and hanging out with her friend when people would come through, and she was repositioning the baby cameras so she could sit there and watch and listen to everything on the monitor. And the reason it came about is because the buyers who bought the house were having a conversation with their agent, and don't give me the amounts, right? But for instance, they were going to offer $25,000 lower, but they were willing to pay full price because they absolutely loved it. Well, she heard it. So what happened? They made the offer, they rejected it and said, no, we want full price, and they paid it. And it turned into a lawsuit because they had an expectation of privacy in the home to have that conversation with their agent. It was a long time ago.
Yeah.
But that's where that all came from. Okay, so anything else that is a condition of the contract, then you have to put in here. Okay? Okay. All right, that is our, we're so behind on time. Okay, that is our listing agreement. If you have other questions on it, write it down. The other one that I want to go over with you today that is super duper important, if we don't get through anything else, is our seller's disclosure.
Right there are two. Oh, that's just
Yeah, seller's disclosure statement.
it's just the bigger one, probably. The smaller one's in here too.
I think I put both in there for some reason. Yes, so this is, it's right behind your listing agreement. The first one page looks like this. And you probably have two of them in there because I probably have the old one and the new one. So the new one is actually 4 pages because they just made the font so much bigger. And
So should we ditch
I-
this one?
yeah, you can ditch that one if you want to. I begged and complained and begged and complained to the Garage Forms Committee for years because those check marks and the font was so small that anybody I had like over the age of 60 could not read it. And it was so difficult. So they finally listened, and now we have the big one. On the disclosure statement, you may not fill out this form. You can write the property address at the top, but then you may not fill out the form. The seller has to do it. And this is where we get a lot of misinformation as well. Agents don't know how to fill out the form, so they don't teach their seller how to fill out the form correctly. On this sheet, this is, yes, it works. No, it doesn't work. I don't know if it works, or it's not available on my home. Okay? If you check mark, yes, it works, then when you hand that property over to the buyer, it still has to work. Does that make sense? Okay. The other common misconception is that if it is checkmarked on the seller's disclosure, that it is included in the sale. Not true. You have a lot of people that are going to reserve the washer and dryer. They're going to take it with them to the next home. If it's checkmarked on here, that just means it works. If it's not included in the purchase agreement, it does not go with the house or stay with the house. And I have had so many agents over the years too, where like we've gotten to the closing table or they do that walkthrough and they go, well, we've got a problem. And I'm like, really? Like, what's the problem? Well, the washer and dryer are included in the sale. No, they're not. Well, yeah, they're checkmarked on the seller's disclosure. Yeah. And on the purchase agreement, it does not say that we're including the washer and dryer. You didn't write them in. We didn't agree to them. They don't stay with the home. Okay, so this is a disclosure of what the seller knows about the property. It is not a list of what's included. Does that make sense? Okay, so again, like oven, dishwasher, refrigerator. And again, if the oven is included and we said it works and they wrote it in on the purchase agreement and then it breaks down 3 days before closing, we have to replace that item because they asked for it and we told them it works. Let's say that we know the dishwasher doesn't work and we check mark, no, it doesn't work. And they asked for it included on the purchase agreement. Okay, fine, yes, we said it's included. We also told you that no, it doesn't work. And then they go do their inspection and they come back and say, well, the inspector found out that the dishwasher's broken. Yeah, it's on the seller's disclosure that it doesn't work. Or, forget the inspector. Let's say they go do their final walkthrough and they try to turn on the dishwasher and it doesn't work. And then they call you and say, well, we've got a problem. The dishwasher's broken. You've got to replace it. No, we don't. We did include it, but we told you on the disclosure that it does not work.
And they accepted a broken dishwasher.
And they accepted it. Okay. So that's how this part works. And if it's something that they don't have, it's an NA. So let's say that you're on city water, you don't have a water softener or a conditioner. That's an NA. It's not available on this home. Okay.
Meaning it's just not there. They could put one in the future.
Sure,
Okay.
but it's
Alright.
not there, it's not available. It doesn't have underground sprinklers.
Right.
It's not available.
Okay.
NA. Okay, and then here it gives you like additional explanation sheets if you need. Unless otherwise agreed, all household appliances are sold in working order except as noted. Without warranty beyond the day of close. Alright, now it's gonna say, basement crawl space, has there been evidence of water? Yes or no? If yes, please explain. This is one of my favorites. And I asked my people, right, have you ever had water in the basement? Nope. Okay. I have a question. When I walked through it with you earlier, and we were in the living area downstairs, you could see on the paneling that there was a line, right, where water had been on that paneling at some point in time. Can you tell me what happened there? Well, we have no idea. It was that way when we bought it. We've never had any water since we've lived here. Like, okay, great, then we're actually going to explain that the same way you did to me. Because when those buyer's agents are walking through the home, they're gonna see that watermark the same way that I did and think that we're lying to them. So we can check mark no, and then we're going to say, not while we lived here. You know, there is a noticeable watermark on the paneling that was there when we bought it. We can't attest to what happened before we owned the house. But you never want to give the appearance that you're lying. And they have to be honest on this. This is the form where people get sued. Okay? Very, very serious. As honest as you can possibly be. Alright, then it's going to say insulation. Describe if known. Some people do, some people don't. Roof leaks. Does it leak? Yes or no? What's its approximate age? And again, if something happened, I want to know. Tell them as much as you can, right? Let's say that there's a section that's just a little bit off color from the rest. Everybody's going to notice that. Tell them why. You know, roof branch crashed in and we had to have it repaired in 2016. Tell them. I have had very few people in my career who have ever known the well depth diameter. 4 inches standard for wells, but most people don't know. So I say, if you don't know, leave it blank. If you know the age, if you know the repair history, you know, when was the last time the water was tested. Okay. Septic tank, drain field, again, and this is another important one too. You need to know where the drain field is. Right? Normally you're gonna see kind of like the pipe sticking up out of the ground, and you'll see that like one section is way more greener than everything else, so that's usually where your drain field is. But here's the thing, especially if you're looking at a larger parcel, you know, even something that's like 0.7, 0.8 acres or up, people want to put in fences, they want pole barns, they want pools, all that kind of stuff. You need to know where the drain field is, because that can impact what that buyer is going to want to do with the house. And you will get that question. Where's the drain field? The buyer wants to put a pool in. Okay. Heating system, plumbing system, electrical system. And this cracks me up too. People will go, electrical system, like what are they asking? I'm like, do we have lights on right now? Uh-huh. Have you seen sparks coming out of anything? Nope. Then you have one and it works. Go ahead, Jada.
I have a question about that.
Yes.
So I have a listing coming up next month, and with their electrical system, they have like one light at the top of the basement stairs that won't shut off, like it just won't turn off. Are they able to like unscrew the light bulb? Or,
It's at the top of the stairs?
It's in the basement, yes. So the basement stairs, the light at the top won't shut off at all.
Well, then you have to disclose that. You know there's something wrong with the electrical system.
Right.
And I would not just unscrew it because somebody's gonna fall down the stairs. But that is the type of thing that will get you sued.
Yeah.
Because you are aware that there's a problem that you're not wanting to disclose. And more than likely, Jada, like buyers coming through, they're not gonna notice. They're just gonna think they can't find the switch.
Yeah.
Right, to get it turned off. But an inspector's gonna find it. I would recommend that they go ahead and have it looked at.
Yeah.
Because obviously there's something wrong with that thing. Okay. Then history of infestation, termites, carpenter ants, carpenter bees, right? That's the kind of thing that we're looking for here. Environmental problems. Do you have flood insurance? Most people don't. If they have flood insurance, they usually know if they have flood insurance. But why is this important?
They'll have to get flood insurance, new owners.
And flood insurance is freaking expensive. And here's the thing, FEMA redid all of our flood maps 2 years ago. So stuff that you might not even think is in a flood zone could potentially be in a flood zone. And it may not have been updated through their insurance companies right now, but when they go to get new insurance, it will.
Oh no.
So, there is an easier way to get to this, and I always forget. But anyway, I just went to FEMA flood maps right here, okay? So, let's say that I search this. Okay, so I am not in any kind of flood zone. See, I got nothing going on there. But what will happen, see here, like you've got these, and then you've got these, and it'll show you the different areas. Let's just see if I get to,
Oh, like anywhere in Grand River.
yeah, well, not just the river too, downtown, so.
Like Grand River,
They've got some sections, don't they? that's the lake, so that doesn't really flood. Now we're down into Kentwood. This is 8.
There.
Okay, now we're showing it. So, you see your lines right here? And then it's gonna tell you the different zones. So like right here, like zone AE, that is considered an extremely high risk flood area. And so if anybody has that check marked, when you have your buyers, you need to pay close attention to that, because it means that you need to know, like, what are they currently paying in flood insurance? And then you need to find out what they're gonna have to pay in flood insurance.
So it's required, if you're in that blue zone,
If
it's
FEMA has
required.
you in certain zones, it is required.
Okay.
And again, the best thing to do is if there's a question about it, call Treadstone and say, this looks like it's in a flood zone, what can you find out for me?
Okay.
And then they'll be able to tell you, and then you can figure out what it means in insurance. And there are ways to get that removed too, right? That you can get a, certificate of elevation. You have to go, it costs $2,000 to $3,000, but they go through, and that's where the engineers, right, will look and see.
Oh my God.
I had a property on a lake a few years ago, we were around 750,000, and FEMA had this one, like, low-lying corner designated as a flood zone.
No way.
And the house was all the way up here, but because that one little corner was touching flood zone, they wanted to require flood insurance on the entire property, which was gonna be $12,000 a year. So for us, it was cheaper to go through and do the 3,000 and get it reclassified and recertified, because nobody was gonna buy it have an additional $12,000 a year in flood insurance.
So once that reclassifies, it stays with that property.
It
for
does.
the duration of,
It does.
yeah.
Yep. So, alright, I see Aubrey's bringing me her ticket.
I am,
Okay.
sorry.
Thank you, I know you have to go, all good, and I'm sorry that this went longer, but really this class, there is no way that this can be taught in 3 hours
You
and
could
actually
split it
touch on
into
everything
two.
you have to.
You could actually go into 2.
Yeah, we'll probably do that for the next one.
So much.
So it's normally Ed though, and then, I was like, how did I end up doing this one today?
This is great though, thank you. Yeah.
Most people don't know if they have mineral rights, so they usually, I say, if you don't know, then check mark unknown. Okay, then it's gonna ask like features and property shared in common. That's if you share a driveway, right? A lot of our properties in Grand Rapids share driveways. Go ahead, Josh.
It's kind of like a random, how far down until you hit mineral rights, technically? Like, how much of the property do you actually own?
Have to go under?
Yeah.
That's a good question, I have no
Because,
idea.
like, if you have a basement in the ground, I mean, I just am wondering what the definition of that would be then.
I honestly don't know,
I don't
like
get
how
it
far it
either.
has to go down, but usually what they're asking is, you can sell the mineral rights.
Right,
Like
yeah.
you can still own a property and sell the mineral rights. So, for instance, in Caledonia, on Thornapple River down there, I've sold a few of those houses. But there were a couple stretches where they owned 10 to 15 acres. And what they did is they kept like the 2 acres next to the house separate, but then like for the back 6 acres or something, they would sell or lease the mineral rights. And those companies would come in and take, you know, like the ore or the limestone or whatever they're looking for out of the property. So they still own the property, but somebody else owned the mineral rights for a period of time.
Okay.
That's where you run into that kind of stuff.
Gotcha, alright, thank you.
So then they're basically leasing that land to that company? They're getting paid, yeah.
They can lease it, but they can also flat out sell it.
I'll just sell it, yeah.
And once it's sold, once the mineral rights under a property are sold, they're sold. It's like the next owner no longer has any control over the mineral rights on that property.
Wow.
You get a lot more of that like in Texas when you're dealing with oil, right? And those kind of areas, but it is there. Okay. Encroachments, easements, zoning violations or non-conforming uses. Common areas, this is usually HOAs, right? Like if they have a front entrance that's all shared in common or a clubhouse or something. Then it's gonna ask about permits, flooding, drainage, structural problems, major damage from fire, wind, and landslides, underground storage tanks, farm operation, proximity to a landfill, airport, shooting range. If you live within 15 minutes of the Grand Rapids Airport, you live in proximity to an airport. you live in Byron Center, you probably live within 15 minutes of a farm operation. Outstanding assessments, any pending litigation, and then you can fill anything else out on here that you need to disclose. Then it's gonna ask, like, they've lived in there from when to when, and they've owned the property since when, and then they sign off.
For the farm nuisance
Yeah.
thing that you have to explain, I'm trying to remember if I heard it correctly in school, it was within a mile of that farm, right?
It is, for a farm, it is supposed to be within a mile.
Within
What
a-
they're looking for is nuisance or noxious, you know, like odors, smells,
Yeah.
that kind of thing. But with the airport, it is more like 15 minutes,
Yep.
because if you're in a flat flight path, that is still
Noise.
considered proximity to the airport.
Yeah.
Okay.
Yeah.
Isn't it interesting how flight paths change?
Yeah,
Mm-hmm.
it's not very noisy.
Well, with GR, it depends on the wind patterns. So they normally keep the north-south runways open. But on certain days, if the wind is at a lower level, they will also open the east-west. So like I am one of those where if they open the east-west lanes, then we get traffic overhead.
My
If
sister
those are
lives in
closed, we
Ada,
don't.
gets that, yeah.
I get them overhead, but I don't pay attention anymore, I don't notice it, they're not loud, like, I must be just far enough, but we're really close to there, we're
Yeah.
less than 15 minutes, but I don't pay attention to it, I guess, anymore.
Okay, I was gonna hand everybody one of these too. These are packets from Treadstone, just for you to have, to be able to look over with your buyers or whatever.
Question about the seller's disclosure, so if this isn't filled out, technically, the buyer can get out of.
Well, no, because the other part of that says that they have to be provided and sign off within 72 hours. But here's the
Oh,
thing,
okay.
when you put a listing on the MLS,
Uh-huh.
if you don't have that document uploaded, they will delete your listing within 24 hours.
Oh, okay.
They will send you a notification and say you're missing XYZ, you have 24 hours to fix it, and if you don't, then they yank the listing.
Oh,
So
okay.
you have
They're
to have
on
it filled out.
Okay.
Yes. All right, what other questions does anybody have today?
I have a random question.
Trade you for your ticket.
Yeah.
You got it, Miss Jada.
Also about the seller's disclosure.
Uh-huh.
So, do you have to put any like, or disclose any like cosmetic issues, like for example, like if the doorbells don't work? And they
Yeah.
don't wanna like necessarily like pay to get them fixed, you have to disclose specifically like if doorbells aren't, like don't work to the property or something.
There is no line on there,
Yeah.
right, unless it's something that you wanted to put in the other issues.
Yeah.
But I probably wouldn't for anything like that. I mean, most of the houses out there probably don't have working doorbells anymore. It still has them there because they
Okay.
bought a Ring camera,
Yeah,
right?
Yeah.
So I wouldn't worry about that.
Okay, no,
And
it
if-
was just a random thing, cause like I said, my listing, like the doorbells don't work, so I was like,
Yeah.
I don't know if we have to necessarily disclose that.
Well, a doorbell too is one of those where you might have the ringy dingy on the outside, but usually you have some kind of portable thing that's just screwed onto a
Yeah.
wall up here. It's not a permanent fixture
Right,
of the home.
yeah,
Your roof is.
you're right, so yeah, like anything like cosmetic related, it's not necessarily has to be.
No.
Okay,
Nope.
I figured that, just wanted to make sure.
No, that is all good. And again, we did not get through all of the forms, but your packet does have all of the forms. So if you wanna go through and take a look at those, you are welcome to do so. If you have questions about them, let me know. I'm happy to answer them. And give you one of those. That's got all my contact on it, Carrie. Thank you. Uh-huh. In case you have any questions. Yes, we're good.
Cool.
Thanks, Trish, John, anybody else that was out there today?